negative aspect of whatever judgments are there against doctors. So thank you, Dr. Erande. You have always I have enjoyed reading your blogs and whatever you put up on the social media. And you are the apt person to talk today on the medical legal issues which the doctors and the laws which are there. So welcome, Dr. Erande, and we are eagerly waiting to hear your words of wisdom as far as the medical legal laws are concerned. Thank you very much.
Yes. Thank you, Uttore sir. And thank you very much, IMA Dombivli, for inviting me. I think for the first time I've been invited by IMA Dombivli. And let me begin with the word of appreciation for IMA Dombivli, that I have attended so many conferences, but time and again, for every movement, the messages are being circulated that your topic, this topic is on at this time and this time. I am getting phone calls, so they are trying to make the everything goes by schedule. Few minutes here and there, we all appreciate. So not to be worried at all. And I congratulate IMA Dombivli for completing 50 years. I just heard one of the doctor was saying, and I wish them best of luck. And now let's move to the topic given to me, as the time schedule is very less. Now, medical legal cases. Now, I would say that there would not be any doctor who is not afraid of any medical legal cases. And nowadays, it is said that every patient is a future litigant. At this stage, every doctor is saying that now, by some or the other way, he'll be entangled in a medical legal case. So now let's see. This is a very vast and deep subject. So I will just try to put my talk in very nutshell. Now let's see what is medical legal cases, because medical legal cases have both aspects, civil and criminal, and so I will be touching both the aspects in short. Now, as the name itself indicates, MLC is a case which refers to injury, illness, death, or that requires intervention of law enforcement agencies. For example, road accident cases, suicide cases, or cases filed by relatives or patients against the doctor for negligence. So, if you combine all these cases, come under the heading of medical legal cases. And now, as I have stated, medical legal cases can be broadly classified in two aspects: civil and criminal. Now, civil cases and criminal cases. Now, first of all, let me say that you cannot stop anybody from going to the court. We always remember that in not only in medical legal format, in any sphere of the life, whosoever may be your opponent, or whom he has right to approach to the court. But merely a case has been filed in the court does not mean that the plaintiff or the complainant is going to win the case. So always remember that merely a person has gone against you in the court, abhi sab kuch khatam ho gaya, aisa nahi hota hai. So don't take uh, in that negative fashion, because the burden lies on the plaintiff, the complainant, to prove his allegations, and therefore always remember that you always get a chance to defend yourself in the court, and you can always point out the fallacies in the case put forward by the complainant. Now, any case starts with a general phenomenon of sending a legal notice. A patient, for example, if is not satisfied by your treatment, or something goes wrong, you may find that a patient has served a legal notice upon you through his advocate. Always remember that, always accept the notice served upon you by the postman or by courier, because there is a common tendency to refuse the summons or refuse a notice which is served upon you. See, if you refuse it, that does not mean that now the case will not be filed. Rather, it will be, I would say, that a disadvantage for you, because you won't be able to come to know that what are the allegations against you. So always remember that you accept the notice, consult your legal consultant, and send that proper written reply. So that is always important, because there have been cases wherein not to file reply has been treated as acceptance of all the allegations made by the complainant or the patient. So always remember that, accept the notice and send a counter reply in time. Now, if we go for a civil medical legal case, then obviously that is related to compensation, as all the doctors are aware that the CPA, these three letters are very dreadful for doctors: Consumer Protection Act, wherein the patient or his relative files a case for claiming monetary compensation against a doctor. And what is criminal MLC? Criminal MLC, suppose in the road accident cases or suicide cases, a patient dies and a police complaint is made against doctors within a purview of criminal MLC. Or if a patient dies in the hospital, then the criminal law comes into an action and a criminal case is filed against the doctor. That may be called as a criminal MLC. Now, criminal cases, as earlier doctor, the well-known speaker, has already stated that the criminal action against doctor. Now, if a patient dies, then the most dreadful section which may be applied by the police is section 304 part 2 of the IPC. That is culpable homicide not amounting to murder, and it is non-bailable and cognizable offense. Wherein suppose a 304 part A is applied, that death by causing rash and negligence. It's a 2-year imprisonment offense and it's a bailable offense. So which section is to be applied? It is the prerogative of police, and therefore now if 304 part 2 is applied, then the doctor has no other alternative but to approach to the Honorable High Court for getting the bail. If 304A is applied, then as of right, a doctor can get a bail. So these are two important sections of IPC under which a doctor can be booked for criminal cases. I have just now shared my one of blog on the rights of doctors against arrest in our chat box. You may just go through it. Now let's move to the further aspect of how to defend a medical legal case, because most of the times I would say 99.9% doctor is always a defendant or doctor is always an accused. He's never we have never seen a doctor is filing the case against patient for recovery of amount or for giving for filing a false case and therefore pay me the compensation. Actually, this should be the other way around. Doctor should go on filing the cases, but it's altogether different thing. Now, before defending any medical legal cases, the first and foremost duty, which I would say that every doctor should now imbibe this habit of maintaining a proper record. See, in any court of law, record only speaks. So, poor record is poor defense, and no record is no defense. You just imbibe this word that if you don't keep the record properly, then you are going to lose in the court of law, because ultimately the court is going to see what the record you have put, what are the discharge summary and etc. etc. So keeping, you may examine 2 or 3 patients less. I always say in my all the lectures, but see that your record is properly kept, because there have been cases where doctor has been discharged for medical negligence but have been saddled for not keeping the record properly. And never try to tamper with the record, because you are liable to get caught, because जाम मराठीत म्हणतो जसं की एक चूक लपवायला एक खोटं लपवायला 100 खोटं बोलायला लागतं. So in the similar way, never try to tamper with the record. Another important aspect for defending the medical legal case is of consent, informed consent. Now the law is no more res integra. That is, law is now clear. All the doctors are aware that what is informed consent, how a consent should be taken, and that is what are the pros and cons of doing a particular procedure and not doing a particular procedure. This is what in nutshell the informed consent is. Now I have seen personally that in many cases senior surgeons, senior doctors avoid to explain the pros and cons of that particular surgery with the patient, and the mama or the ward boy who takes the signature of the patient on the consent form. I have seen personally in my personal case. At that time, I was talking to doctor. Look, I know what is the law of consent, and don't take it lightly, because as Utturi sir has rightly said, one medical legal case can ruin your career. So you may examine 2, 3, 4 patient less, but don't overlook the important aspect of informed consent. Another important aspect of defending a medical legal cases is expert opinion. Now, in civil cases, the law is a little bit different. In criminal case, the Jacob Matthews case has already settled the law that before taking any criminal action, police should have the expert opinion from the concerned government hospital. In civil cases, earlierly the landmark judgment of Martin D'Souza of 2009 judgment wherein Supreme Court made it mandatory for having expert opinion before instituting any consumer complaint. But subsequently, in Nikhil Super Speciality Hospital case, Supreme Court has now, I would say, reduced that particular section, or reduced a particular provision, and now it has stated that only in exceptional cases or complicated cases, filing of taking expert opinion is mandatory. Otherwise, it has left to the wisdom of the particular consumer forum. However, nevertheless, a doctor always has his right as a part of his evidence to submit the third party expert opinion or whatever you may find from your colleagues. So that is going to help you. And the law on expert opinion is again different. So suppose you produce some expert opinion at it is an opinion. Any opinion is never binding upon the court. So it's not only in medical cases, in any other cases, opinion is not binding upon the court. For example, in court we may have to examine a handwriting expert for proving the signature or this thing. The courts have stated that ultimately court will decide whether the expert opinion is binding or not. Majority of the times courts do rely upon the expert opinion, but there have been cases of National Commission where the National Commission, in spite of having an adverse opinion against the doctors, have decided in favor of doctors. So it always remember that even if an expert opinion, because many of times we have seen that the patients have filed expert opinion of forensic expert. So the National Commission has held in one of the judgment that forensic expert cannot be said to be the expert in all the medical legal cases, because he can give a medical expert opinion on neurological cases as well as gynecological cases. So the National Commission said that we by no stretch of imagination we can say that whatever he's stating is a gospel truth. Now, another important aspect of defending medical legal case is, I would say, it is by the doctors and for the doctors. That is having an perfect indemnity insurance policy for oneself. Nowadays, I would say that every doctor should have at least 1 or 2 crore rupees indemnity insurance policy, which are available in the market, and the premium are very less. But if as we all are aware that maximum compensation till date has been granted as 11 crore rupees in Kunal Shah's case, 11 crore to 1 lakh. So this is the range. So Supreme Courts or National Commissions have been awarding compensation from 1 lakh to 11 crore. So you never know which kind of case is going to be filed against you, and which kind of specialty you are practicing. So according to, I would always advise my medical friends that you have proper indemnity policy. The further important aspect is, I would say, from my own experience with as a lawyer for last 20 years, I would say that two words with the patient and his relatives. If you spare few, uh, if you share few seconds, few minutes with your patients and have words with the patient and the relative, that is what the patient wants. If you are not attending the patient, if your junior resident is attending the patient, then the patient may have no confidence against you, and patient may start thinking that, "Arey, isko to aata nahi." He just already the relationship between patient and doctor is in vicious circle. So always it is doctors are blamed that वो तो लुटे रहे हैं, उनको खाली पैसा ही चाहिए. मतलब what is the tendency of the patient? If you tell the patient to do some particular test, patient would say, "अरे पैसे निकालने के लिए टेस्ट बोला है." If the test results are negative, nothing happens, then patient would say, "Yes, we are telling that पैसे के लिए test बोले." If you don't ask patient to have test and something goes wrong, then patient would say, "Why doctor should have at that time only told us to undergo the particular test? We would have readily gone through the test." So now a clinical practice, and so the practice has also changed. You all are practicing doctor, so you must be aware of the fact. So all again revolves down to having two minutes proper words with the patient, and mind you, it will save a future case which is to be filed against you. And last but not the least, in case, suppose if a if a case is filed against you, and if you are aware that yes, there were chances that you were negligent, or every person knows whether he has committed any negligence or not. So you should talk to your conscience. And I would say that if it is possible, if you are aware that yes, you had committed some negligence, of course you should not have any intention for it, because no doctor has intention of causing harm to his or her patient. But something goes wrong, then I would always say that try to settle the matter outside the court. So it has also, because ultimately, if you go to the court, it is going to cost you your money, your time, and your mental peace. You don't get mental peace in the market. So I'm not saying that you should always compromise, but you know what are the cases which should be compromised, and therefore this is a practical advice I may give you, that as far as possible, try to negotiate with the patient if something goes wrong. Otherwise, if you are 100% sure that you have not done anything at all, and if you have proper record, etc., then you certainly fight right up to Supreme Court. And as I stated at the start of my lecture, that if the cases are filed against you are dismissed on merits, then I would request all the medicos that at least some of you should file a case for malicious prosecution damages against the patient, because none of the doctor want to want to entangle into the court. But unless and until at least someone from you takes this particular step, it will give message to all the other 100,000 patients. So this is my earnest request to every, at least send a notice. Not to file a case or not, it's a different thing. So I'm just concluding my talk on this particular topic, because it's a very deep topic, and we are running out of time. So I once again thank you everyone for patiently listening to me, and over to Dr. Utture sir. If you have any questions, you may ask.
Sir, there are a few questions in the chat box. Laddad sir, could you please take up the questions? Laddad sir? Laddad sir?
I think he's not seen, Archana.
Okay. Suchitra, could you please take up the questions which are seen in the chat box?
Yeah, he's come. Dr. Laddad.
Laddad sir, there are questions in the chat box. Sir, aap lenge, please?
No, I am unable to open that. There is
Okay.
some problem with the internet.
Okay. Suchitra, could you please take up the questions?
I'll take the questions. One of the question is, please suggest which is the good company for doing indemnity for hospital.
It's a, I would say, right question to wrong person. I think you ask your insurance agent, frankly, because there are many policies, and your insurance, or rather for that purpose, hospital would suggest you. Because, and one more point I will just ask at this juncture, that there is a Supreme Court judgment wherein recently it has held that a policy taken by hospital will not cover its doctors.
Yes.
In that case, the doctors were not saved by the Supreme Court, and said that the policy for the doctors cannot be used for its consultant, because the policy was like that. So always ensure that whatever policy you are taking is comprehensive.
So the
Right.
next question is, do doctors working in government hospitals need to have indemnity, or are they protected by the hospitals?
No, it is better to have your own indemnity.
Okay. Sir, can you please throw light on Google reviews which are posted by the patient to defame the doctor and the hospital? How should the doctor respond to this?
See, the Google reviews once posted cannot be withdrawn or edited unless that person wants. So you have to immediately reply to the whatever review which has been written by a particular patient. But at the same time, if you think that the patient has really made some derogatory remarks against you, then you should see that you take a proper legal action by sending a notice at least. And then you have two options: either to file a case for criminal defamation, or to file a civil defamation case for claiming the compensation.
Okay. Now
Suchitra, I think we are running short of time.
Can I ask
request Dr.
Please, sir. Please, sir.
Dr. Kamath, can I just ask two questions, important questions?
Yes, sir. Yes, sir. Please.
Rarely we get an advocate whom we can question. So, Advocate Erande, you said that the police have a right either in 3042 or 304A to file the FIR. But after the Jacob Matthews case, And now, especially after the Supreme Court has asked the National Medical Commission, when I was a member of the National Medical Commission, we have given a detailed this of when a criminal case can be filed. Can the police really resort to 3042 in such cases, or will they be wrong in doing that? And the second question is that, in our medical field, I am a surgeon. I'm definitely not allowed to do a cardiology case or, ophthalmic case. But what I find when we were sitting even in the council, a lot of cases, unfortunately, I'm sorry to say, but were botched up by the wrong advocate who had come to, defend that particular doctor. So is there anything in your field also where you cannot do, a case where you're not specialized in? Because medical legal is a very niche, this law is very niche law and very specific. So is there any way that, we as an association can also interfere as far as this is concerned, where, there is corporate law where there is corporate lawyers who do that. There is a criminal law where only criminal lawyers, but in medical legal, any and everybody comes there as a lawyer to defend our doctors. So is there any way we can try to improve on this? These are the two questions that I would ask.
Yeah, firstly, I will come to the second question. Once we get a LLB degree, this is the basic degree, we are allowed to practice in any field, and there is no embargo upon, there is no specialty as such as the doctors have, ophthalmologists, orthopedic, gynecologists, neurologists. There is no such specialty for lawyers. It all depends upon the practically, which side, which cases you take, what is your liking, and you go on practicing. But certainly we cannot say that you are a medical legal expert or not, because there is no any such degree which is awarded by Bar Council of India, or we don't get any such special separate degree from law colleges. So all the all the lawyers are allowed to represent the doctors in MLC, irrespective of whether they have this knowledge or not. I think I would suggest doctors to be wise and to select their lawyers and to whom to engage, because it is their right which lawyer is to be engaged. Now coming back to the first question, now again the Jacob Matthew or the subsequent Lalita Kumari case, wherein the Supreme Court has stated that before taking any criminal action, mandatory inquiry is a must. But in both the cases, Supreme Court has not stated that police, which section should be put by police and which should not be put. It is always the prerogative of police, because even if you see not in any this medical legal cases, in any other cases for some little brawl or fight in the society, police are entitled to put any sections under the. It is their prerogative. Subsequently, the court has power to discard the sections put by the police. But it is the prerogative of police. But in either of the cases, for 304 Part 2 or 304A, in criminal action, mandatory expert opinion is a must.
Thank you.
Thank you.
Sir, Utture sir, what I feel is that, we also should, as Doctors Association, we should take the background of this, that lawyers with LLB degree can practice all the specialties, So at least what is taught in our curriculum, at least we should be allowed to practice at least that aspect of it, because somebody who has done, I would say, MD medicine, you are taught diabetes in the curriculum, you are taught cardiology in the curriculum, but still you are not allowed to treat, it's okay, you are not allowed to call yourself as diabetologist or cardiologist, but not allowed to treat if something goes wrong, that why you did not call the specialty. So something on this aspect, we all need to come together and work on this aspect is what I really feel. So over to you, Dr. Suchitra.
Yes, sir, I request Dr. Shivakumar Utture sir to thank Advocate Hirande.
Yeah, I think excellent. And the best part of the whole talk was practical aspects you spoke about, the consent, how to take the consent, and especially documentation, which is one of the most important things, whichever the court is, may it be MMC, may it be CPA, may it be criminal court or whatever. So thank you very much, Advocate Rohit Hirande. As I said, it's always a pleasure hearing you whenever you talk on medical legal cases. And I hope you go on being a friend of the medical fraternity even in the future. Thank you very much.
Indeed.
Sir,
Thank you,
we
thank
need
you.
more people like you who are friends of doctors. We really need more people like you.
Yeah,
Thank you
thank
so much. Yes.
Thank you.
On behalf of IMA Dombivli, we present the certificate of appreciation to Advocate Rohit Irande sir for his comprehensive and elaborate session for medical professional on overview of medico-legal laws during the online medical legal Let's Act Summit organized by IMA Dombivli on Saturday, the 29th of July, 2023. I thank Dr. Shivkumar Utture sir and Dr. Anil Ladder sir for joining this session. Over to you, Dr. Archana.
Yes.
Thank you.
Thank you once again, Irande sir, for that wonderfully elaborate session. Thank you, Utture sir, and thank you, Ladar sir, for being
Thank
there
you.
on the session. Thank you. So moving on to the next session, the Shop and Establishment Act regulates most businesses, including restaurants, shops, cafes, and other establishments. It is compulsory to register your business under the Shop and Establishments Act to regulate the work environment and protect the workers' rights. But do hospitals and clinics fall under the ambit of the Act? If yes, then how, when, and what rules and regulations are applicable to clinical establishments? To speak on this, we have with us Dr. Vivek Tilwani. Warm welcome to the summit, Dr. Tilwani. And to chair this session, we have Dr. Anil Pachnikar, sir, who is the past president of IMA Maharashtra State. And to co-chair, we have Dr. Dhiren Kalavadia, who is the past treasurer of IMA Maharashtra State. To moderate this session, we have eminent pediatrician from Dombivli, Dr. Ashwini Acharya. Over to you, Dr. Ashwini.
Thank you, Dr. Archana, for your kind introduction. Now, it's with the great pleasure I invite Dr. Vivek Tilwani, expert on the subject, Dr. Anil Pachnikar, Dr. Dhiren Kalavadia on behalf of IMA Dombivli. Now, it's an honor to introduce our speaker, Dr. Vivek Tilwani. He is an honorary professor of surgery from GMC Mumbai. He is a member of Legal Cell, DMER, Government of Maharashtra. He is a consultant surgeon at Saifi Hospital, Mysina Hospital, Saint Elizabeth Hospital, and SPNH Mumbai. He is a medical legal consultant at Tilwani Law Association, Mumbai. He is a co-chairman, Anti-Quackery Cell, IMA Maharashtra State. He has authored a book, Consent in Medical Practice, with Justice Dr. S. Radhakrishnan. He has co-authored a book, The Road Ahead, a handbook of medical legal aspects of sexual assault, authored by Professor Dr. Mrs. C. Now, I would like to introduce Dr. Anil Pachnikar, who is chairing the session. Dr. Anil Pachnikar, sir, he's a family physician and practicing in Mumbai since last 35 years. Sir is a member of Jeslock Hospital Transplant Committee. Sir is also chairman Av Council Committee IMA Headquarters. He is the past National Vice President IMA Headquarters. He's past President IMA Maharashtra State. He's past President IMA Mumbai branch. He's regular CWC member since 2006. He is recipient of multiple awards from state and national IMA. Has recipient of multiple awards for the Dharavi model of COVID elimination. Now, I would like to introduce our session co-chair, Dr. Dhiren Kalavadia. He is a consultant pediatrician. He is a medical director at Inlax Hospital, Mumbai. He is a managing trustee, IMA Chembur. He is a past treasurer and joint secretary, IMA Maharashtra State. He is past president, IMA Chembur. Now, I would like to request Dr. Anil Pachnikar, sir, to welcome our esteemed speaker on behalf of IMA Dombivli and begin the session. Dr. Pachnikar, sir.
I am muted. I think I was muted. Am I audible now?
Yes, sir, you are very much audible.
Hi, Archana.
Welcome, sir. Welcome, sir.
Good afternoon to all of you. I welcome Dr. Vivek Tilwani, sir, the pioneer in the medical legal. We welcome you all, sir, for this today's Shop and Establishment Act. In fact, we are very much proud of you that Shop and Establishment Act was not included the medical fraternity because of you. But some person from the Nagpur went to the court again, and we got included into the Shop and Establishment Act. So, this to register our business into the Shop and Establishment Act, is it necessary or is it not? So, we like to hear from the lion's mouth. Welcome, Dr. Vivek Tilwani, sir. Dr. Vivek Tilwani, is it there?
Dr. Vivek, you have been made co-host. You'll be able to.
I was just waiting for
Dr. Vivek Tilwani, sir, we welcome you.
You're audible, Dr. Tilwan, you're audible.
yes. No. I'm just trying to go into my slide. Very good afternoon to all of you.
Very good afternoon, sir.
Good afternoon.
Okay. We are going to talk about the Shop and Establishments Act. The problem is, I think there is some issue coming up. 1 minute.
Yeah, issue is there in the Shop and Establishment Act. We would like to resolve with you.
Yes. No. Just a minute.
सर मुंबई की बारिश ने सबके नेट को जरा प्रॉब्लम में डाल दिया है. So I think
No. What I have done is,
yes, we can see you in a twinning avatar.
yes, that's exactly what's happening now. If you can make me a twinning co-host.
Yeah, I'll do that. I'll make you a twinning co-host. Yes, your twin has been made a co-host.
Great. So I think there should be no issue now. I think we should be able to see now.
Yes, it is seen.
Yes. Okay. So sorry for the delay. Okay. Now this is a
Most welcome.
topic which would require a lot more consideration than we actually imagine. And I can actually write a thesis on this, but given the time constraint, I'm going to go through very fast. And I'm going to put certain points clear as I've heard from the queries. Now, the first and foremost question is, what is the law which we are referring to? So prior to 2017, to be precise, the 7th of December, the law on this was governed by a statute, that is the Bombay Shops and Establishments Act 1948. It came into force on the 11th of January 1949, and it ended its tenure on the 6th of December 2017, when it was replaced by the Maharashtra Shops and Establishments Act 2017. There are some differences in both these, and therefore the applicability will be different. The definition of establishment as defined under the Bombay Shops and Establishments Act originally did not include professions. However, in 2017, professionals are included in the definition. The second cardinal difference is that a commercial establishment was defined separately under the old act. Whereas in the new act, there is just one definition which covers everything. This is the new definition. Sorry, this is 2017, but by mistake, it's 1948 that's come up. The next is the definition of shop, any place which sells or provides services. This is also differently defined in both these acts. Now, this is where the difference comes up on whether we are covered, whether we have to register, whether we have to give intimation or not. So the first question is applicability. Now, the provisions of the Bombay Shop and Establishments Act 1948 were mandatory for all establishments which come under the act, of course, irrespective of number of employees. Whereas in the 2017 Act, it says that if you have less than 10 employees, you only have to give an intimation. You do not come under the mandates and provisions for higher number of employees. So this is one of the major differences. Even if you're running a clinic with 8 people, you will not be affected now, whereas you would have earlier been affected. First and foremost difference. Then the definition of employee under the old act and new act are different. Under the old act, family members of the employer were not included in the definition of employee, whereas in the new act, they will be included. But there are other exceptions. One is custom, the short form, the long form is given here. Clerical, unskilled, skilled, technical, operational, and manual. But those holding a confidential position, managerial position, or supervisory position are exempt under the new act. In short, for a question, if you try to put a question to me today as to whether you are covered or not, your entire establishment setup, your organizational setup, and your operations setup will have to be seen on a case-to-case basis to identify whether you are covered or otherwise. Now, there are certain alterations in operation and rest timings. As compared to the old act, there are differences in the new act. Every 5 hours, you give a 1 hour break in the old act. In the new act, it's a half an hour break. Number of hours, how do you pay for the overtime and wages? Not more than 125 hours of overtime at a time, in a month. So these differences will come up. Then there are certain changes in leave provisions. How many leaves to be given? What is the calculation? Who is eligible for leave? How you give it? There are differences in the old act and in the new act. That's another difference coming up. Then there are special provisions for safety of women in the new act. Women are not supposed to be forced to work between 9:30 p.m. and 7:30 a.m. In short, night shifts. However, if women consent to night shift work, then special provisions are provided, including a doorstep pickup and drop. Then there are change in the penal provisions. What penalty can be imposed? And of course, there is one more difference. Under the old act, the officer who would come in for enforcement was called the inspector. Under the new act, it is a facilitator, not an inspector. The difference is the inspector has a unilateral duty, the facilitator owes answers to you as well. So even if you have a difficulty, you have a right to contact the facilitator. Now let me take you to a little historical journey in the Act. 1948 Act initially, as I mentioned, did not apply to professionals. So who are professionals? Well, the oldest three defined professionals are doctors, lawyers, and priests. And none of them are included. Subsequently, I've got architects, engineers, chartered accountants, all this has come in. But no professional was included in the Act of 1947. Thereafter, gradually, certain authorities of certain states tried to bring in, professionals within the ambit of the Act. When they did that, the professionals approached the various courts of law, and consistently all throughout, the courts have held that professionals cannot be brought into the ambit of those laws. And a similar thing had happened even in Maharashtra. In fact, I'll mention the cases also to you. Well, somewhere around the year 1977, certain changes were brought around. And professionals were again sought to be brought in. This is insofar as Maharashtra government is concerned. They brought in changes and they tried to include all professionals in. But then the courts of law again struck them down. There are a plethora of cases. If I try to name them, if I just give you all the names, will be beyond half an hour. So I'll give you just a few important names. This went on till 2017, when the old act was repealed and new act brought in a definition of establishment, including all professionals. So under the new act, all professionals are sought to be brought in. I'm very clear, sought to be brought in. For the Bombay Shop and Establishment case, there's a Supreme Court judgment of Dr. Devendra Surti versus State of Gujarat. This is a very nice case which has clearly held, the Supreme Court has clearly held that a doctor cannot be brought into the scope of commercial practices. Dr. Kavita Tilwani versus State of Maharashtra is another case of 2013-2014. There also the same thing has happened. The Bombay High Court struck down the amendment as illegal and said that the doctor cannot be forced to be treated at par with commercial establishments. There are many others. And then there are some important cases of the Maharashtra Act as well. So under the Maharashtra Act, what is important? Well, the IMA has taken a first-hand, stand here. It's spearheaded the entire movement by saying that the old act was not applicable and the new act brought on the similar grounds cannot just blindly be enacted and enforced upon doctors. And please listen carefully. The Bombay High Court had granted a stay order on the implementation of the new act for medical practitioners and establishments of medical practitioners. However, shortly thereafter, before I end, let me tell you, this stay order was issued by the Honorable Bombay High Court and the case is still pending before the Honorable Bombay High Court. It has not been disposed as yet. However, before the Nagpur bench, one of the doctors had also tried a similar thing. And in that case, the High Court agreed that it should apply to doctors. And then the matter was taken up before the Supreme Court by a special leave petition. And the special leave petition was summarily dismissed, not on merits, but summarily. The Supreme Court refused to interfere in the matter. However, this IMA case is still pending before the Mumbai bench of the Bombay High Court. I think with this, I should come to an end because I was told that I should finish my talk in 20 minutes. And I think I've done exactly that. So if there are any more questions, I'd be more than glad to answer. Otherwise, I've saved some of the time in this case. Are there any questions?
Yeah, Archana.
Yes,
if I
sir.
could say- if I could
Please,
say-
please, sir.
I think we have to be very, very thankful to Dr. Tilwani, who was my colleague even in GMC, because what he was mentioning, the Bombay High Court case, he fought for us on behalf of IMA and got us that stay order. So I think we should put on record. Thanks, because he is not only a doctor, but he's a very good lawyer. He has got his own law firm also. And even that Kavita Tilwani case, which was there, incidentally, that is his sister,
Yes.
and they fought that case in the court and got that order. So just to put it on record that he has been helping us out in this, shops and establishment cases. Thank you.
In fact, thank you very much, sir. Dr. Tilwani, Vivek Tilwani, sir. You elaborated very properly on the cases, whether there should be.
I think, Dr. Tilwani, if you could just switch off one mobile, your this thing is echoing from the other
I'll do that.
device.
Hello.
Yes.
Yes, sir. Vivek Tilwani, sir. Elegantly elaborated on the Shop and Establishment Act. Thank you very much, sir. And we appreciate your efforts to profession not to register into the Shop and Establishment Act. I heard very clearly about Devendra Surti and the Kavita Tilwani, but a little bit IMA versus Maharashtra, state Maharashtra. I was unable to listen it properly because of some internet connections and all. Will you please elaborate it again?
There is, see, IMA has filed a case. 1 minute. I think I'll just. See, the IMA has filed a case.
Yes, sir.
No, you're muted.
Sir, please.
Vivek, you're muted. Yeah.
The IMA has filed a case. Okay. The Bombay High Court has granted a stay. Therefore, the stay order is in force even today.
Oh, yes.
There is another case, Dr. Pradeep Arora, and that case the court went ahead to say that this provisions will apply. It went ahead to say that the provisions will apply.
Right, sir.
However, thereafter the lockdown took on, and therefore this case is still pending. So the IMA can still move this case and take it ahead to its logical conclusion.
So you are on our sides. We still hope the positive results for all our
Thank you very much.
all our medical fraternities.
Absolutely. Thank you.
Dr. Vivek, a question for you.
Yes.
Thanks for the short and crisp presentation. You said that something is he around? Yeah. So just wanted to know, you said that if there are less than 10 employees, you need to
Yes.
intimate. So
Yes.
in case the stay order goes off, who is the authority you're supposed to intimate? And how do you do that?
Now, there is a form of intimation. The authority has to be given. See, there is a form of intimation. The intimation has to be given to the facilitator. In Mumbai, it is the BMC.
Vivek, if you
Sorry.
can stop screen sharing, I think that would be better.
Okay, I'll do that.
Yes, now it is proper.
Okay. Great. Yes. Now am I audible?
Yes, you
Yes.
are audible.
Okay.
No, Vivek, a simple question which all doctors, we are very simple people as far as law is
Yes.
concerned. As of today, with these two judgments, you said one is a stay order and one is that they are summarily removed. They said
Where
that
do
they
we
are
stand?
there. Should we or shouldn't we register under shop and establishment as a single clinic, doctor, and as a hospital which is employing more than 10 people? Should we or
Absolutely.
shouldn't we?
Yes.
Fair. To answer this in yes and no, the moment you say that there are less than 10, there is no dispute, you don't have to register at all. For more than 10, this is a little gray zone which has to be considered. And ideally, we need to move this matter before the High Court and move it off faster now. That would be a much better strategy.
Dr.
Because
Vivek, I didn't get you. There was a little disturbance. Who is the authority which we are supposed to intimate, because there was a disturbance in your
Municipal authority in urban areas.
Okay, fine. And there is no specific form or something, it is just routine letter?
There is a form, it's available with the municipal authority. You have to just give an intimation and an undertaking that if you ever exceed more than 9 employees, then you will get a separate registration made.
So once you get the registration, you have to go through all the, fulfill all the, and follow all the terms, rules and regulations of the Act, which would be.
Till you have less than 9, you are only intimating. The moment you cross
Yes.
10, all stringencies come in.
So everything would be coming. It's not only registering, but it's also the employees.
Then everything comes in.
So the whole thing will come.
Yes.
Yes.
I
but
think, yes, Vivek, please.
we need to move that IMA matter before the High Court fast and get that also cleared.
I think we are running short of time and our next two speakers are already in session. On behalf of IMA Dombivli, I warmly welcome Dr. Ved Prakash Mishra, sir. He has already joined. And sir, we apologize really sincerely that we are running half an hour late. And you have joined right in time promptly for the 5 o'clock session. Sincere apologies, sir. I welcome past National President Dr. Ravi Wankhedkar, sir. Past President IMA Maharashtra State Dr. Y.S. Deshpande, sir. Immediate past President IMA Maharashtra State Dr. Suhas Pingade, sir. Dr. Arshad Gulam and MMC Administrator Dr. Pallavi Sapre Madam is also there in the audience. So I request Dr. Ashwini to please present the certificate of appreciation so that we can take our next session.
Thank you, Dr. Archana. On behalf of Indian Medical Association Dombivli, we would like to offer certificate of appreciation to Dr. Vivek Tilwani for comprehensive and elaborate session for medical professionals on Shop and Establishments Act during online medico-legal Let's Act Summit organized by IMA Dombivli on Saturday, 29 July 2023. I would like to thank our speaker, Dr. Vivek Tilwani, our chair, Dr. Anil sir, and as well as our co-chair, Dr. Dhiren Kalavadia sir, for their time and participation. Now, I would like to request Dr. Archana, MOC, to carry on the further sessions.
Thank you so much, Dr. Tilwani. And thank you, Dr. Dhiren, for taking this session. It was indeed a wonderful session. With apologies to Dr. Ved Prakash Mishra, sir, and his permission, sir, could we please take the session which is due to come in line? The next session is on MMC Act and Rules. So MMC is a quasi-judicial body. It is governed by Maharashtra Medical Council Act 1965, along with its rules and regulations. It is an act to unify, consolidate, and make better provision in the law regulating the registration of persons practicing modern scientific medicine in the state of Maharashtra. Also, any complaint with regard to professional misconduct by registered medical practitioners in the state of Maharashtra can be brought before the MMC for disciplinary action. To let us know more about the MMC Act and its rules, we have with us MMC Administration, Dr. Pallavi Sapre, Madam. Warm welcome to the summit, Madam. To chair this session, we have immediate past President of IMA Maharashtra State, Dr. Suhas Pingle, sir, and co-chair is Dr. Arshad Gulam, sir. And to moderate this session, I invite upon Dr. Meena Pruthi, who is the Secretary of Dombivli Medical Foundation Trust of IMA Dombivli. Over to you, Dr. Meena.
Thank you, Dr. Archana. A warm welcome to everybody. I would like to introduce the speaker, the chair and the co-chair of this session today on MMC Act and Rules. We have Dr. Pallavi Sapre. She is a MD Pediatrics, DCH, a DNB from Grant Medical College and Sir JJ Group of Hospitals, Mumbai. She's the Dean of Grant Medical College, JJ Hospital, Mumbai. She's the Administrator of Maharashtra Medical Council, an undergraduate board member of National Medical Commission of India, and a Senate member of MUHS. To chair the session today, we have none other than Dr. Suhas Pingle, sir. Sir is the immediate past president of IMA Maharashtra State, medical director of SRMKP Cardiac Institute. He's in private practice since last 46 years. He's worked as a medical officer in State Bank of India for last 10 years. He's a past president and secretary of GPAGP, the General Practitioners Association. He's a past president and secretary of IMA Mumbai West, past honorable state secretary, vice president and joint secretary of IMA Maharashtra State. He's a past member of Maharashtra Medical Council and a past member of Maharashtra Nursing Council. Along with us, we have the co-chair today with Dr. Arshad Gulam. He's the consultant general surgeon, masters in general surgery from TN Medical College, Nair Hospital, Mumbai. He's a trustee and honorable secretary of TNMC Global Alumni Association, a past trustee and president of Indian Medical Association, Mumbai West. I would like to request Dr. Pingle, sir, to please welcome and invite the speaker, Dr. Pallavi, to deliver her talk on MMC Act and Rules. Over to you, Dr. Pingle, sir.
Thank you very much, Meena. And it's my privilege and pleasure to invite the administrator who is in the chair for last 9 months in MMC and the Dean of Grant Medical College. Over to you, madam.
A very good evening. It's evening now. To all the delegates who are present for this session. Dr. Pate, in introducing the Maharashtra Medical Council, probably has succinctly put together my entire talk in a minute, which is wonderful. And I'm sure most of you are aware in bits about what it's all about. And this, the reason I chose to speak here is basically to have a interaction and also a bit of feedback about how we can change things, and also to give you an overview of what's really happening. So with your permission, I'll just start screen sharing.
Yes, madam. Yes, madam, it is visible.
Yeah, it's visible. Next, what do I have? Yeah. So Maharashtra Medical Council, as you've already said, is a statutory body which was established by the government of Maharashtra under the Council Act of 1965. Basically, just an overview of what are the powers, the duties, and the function of the council. So it's basically, or the way I read it is fundamentally, it is to maintain the register and to provide registration to the practitioners to permit them to practice in the state of Maharashtra. Of course, to hear and decide appeals about any decision that is, that is not conducive during the process of registration in the Medical Council register. To prescribe a code of ethics for regulating the professional conduct of practitioners. I'll come to it in a little depth a little later. And of course, to reprimand a practitioner or to suspend or remove him from the register or take any disciplinary action as needed. These are the registrations or the format that we do or the under the various heads under which we do the registration. First, of course, something that all of us have done probably and mostly in Maharashtra would be provisional registration. That any person who desires to be registered provisionally under the Act has to make an application in the prescribed form to the registrar and pay fees as needed. This provisional registration essentially is done for our interns. And the issues that I have seen in the past few months that I've been here is that students apply for the registration a little late in the day. We permit them up to 3 months post the starting of the internship. So the internship ends at the end of 9 months after the registration, and they choose to work for the next 3 months. And sometimes we have had requests and even complaints saying that we had a provisional registration, so I worked in XYZ lab, or I worked with this particular doctor and I need an experience certificate. Some of the students have even gone abroad. They want this, extra months working experience. So just one thing that I need to make clear here is that if they have a provisional registration, whatever the time period mentioned is essentially till the completion of their internship, and it will be exclusively meant for the purposes of doing their internship and not for doing anything beyond that. We need to go back one. Yeah. Also, of course, the registration of for permanent registration, the fees have begun with something as little as 2 rupees. Now the fees are 2,000 rupees, but the process is entirely online. Yeah. Also, we do additional registration. The MMC also registers the additional qualification gets registered into the Act, and anybody who obtains an additional qualification needs to register, get his name into the Medical Council register to be enabled to practice in the state in that particular specialty. Next. I think you will have to go next. Yeah. Renewal of registration. Something that is in the Act is if a student has registered for the first time post internship, then the first time that he renews his registration, we give him a 4-month leeway. So after 5 years, when he has to renew his registration, he has a 4-month sort of free breathing time, in which period he can register post expiry of his registration. But I see most of the delegates have been renewed more than once. So for us, we don't have that kind of privilege. We need to register or begin our process at least 2 months prior to the expiry of our registration. And after the date of the expiry of the registration, the penalty starts, which is 100 rupees a month, as I am given to understand. But I've also seen people pay as much as thousands of rupees when the backlog is for years together. Sometimes there's no other penalty apart from the financial penalty, but sometimes that extends into a few thousands. We have not seen anybody yet pay in lakhs, and I hope that doesn't happen. Next. Yeah. this is a this is an assignment which we have been doing for quite some time. But another aspect that has been added to the medical council's responsibilities is even assigning internships to them. So foreign medical graduates earlier would be registered with MCI, the erstwhile MCI and now the NMC. But now they come for registration to the state council where they want to, once they've cleared the eligibility exams, of course, and then they come to us for registration. And because of the recent COVID crisis and the war in Ukraine region, there is a modification in that, and there's a lot of confusion. But actually, the rules laid down are pretty clear. That if they have done even a bit of their training, undergraduate training online, then they have to do 2 years of internship. And for the first year, if they're doing it in a medical college, the medical college can charge them fees, because the first year of internship is more of a compensation of the lost out period of offline training. And the second year has to be treated as an internship, for which they cannot be charged fees. But I understand some institutes are charging them for accommodation, which is permitted essentially as per the NMC norms. So that is how it works out. Also, from the next year onwards, MMC, as per the guidance of the National Medical Commission, can only assign them postings in medical colleges. Earlier, the story was these students could go to any institute, get their internship done with the permission of the head of that institute, which could even be a civil hospital, which could even be a private multi-speciality hospital. And then they would come to us with proof that they have done 12 months of internship, and we would scrutinize them and give them the permanent registration as the situation was. This no longer is going to happen, because the assignment of the institute is going to happen at the Maharashtra Medical Council level. Next. This is just to give you an idea of the figures. So today, as of today, we have close to 1,83,000 registered medical practitioners on our register. This figure of 1,17,000 is, if you can use the word, active members, in the sense till 30th of June of the last month, we had these many registered practitioners who were in active state, who had renewed it within the legit period of renewal. And of course, the total PG registration is 74,000. And digitization of the records is what we're doing. So every record that we have, the whole bunch of documents are scanned and we are digitizing them. That process is on, but this is not merely just the certificate. We are scanning every document submitted so that it stays on record. And sometimes we have helped other agencies because they do not have old records, and we have fished them out for them. This is a fee schedule which we are right now implementing. Like I said, we are waiting for the amendment so that this becomes, a part of the act as well. But right now, these are the fees that we are charging. This is very much available on the website. These are the amendments that I was talking about. In fact, they have been put in 2021. I'm going to do my best to push them through sometime in the next month or so. They are to do with majorly two things. One is the fee structure, and the other is, although the Act mentions that the Maharashtra Medical Council can maintain a code of ethics, essentially, we don't have an ethical committee the way the National Medical Commission has a separate entity, which is an ethical committee, which addresses all issues related to ethical complaints or anything related to that. We are doing something at our level, but essentially, if it becomes a part of the act, it gets more legitimacy, if I can use that word. Next. Yeah. This is something for which we get a lot of questions. So I thought I need to put this forth, that NMC has published a Gazette notification in which they've said a few things. Let me just briefly go over what they've said, and let me tell you what's the ground reality as well. So what's happened is NMC has said that once a person qualifies for the exit exam, the next as they call, then that person would be registered in the National Medical Register. The other point that they've said, these are the salient features that I've picked up from that gazette, is essentially that even if they're registered, earlier there was a thinking that if you're registered in the central council, so to say, you needn't register in that individual state. But no, this new act says that everybody will have to register in the central register, but to practice in a particular state, you will need to have the registration of that particular state to practice in that respective state. This is more for us that the period of 35 days to issue the certificate back. I'm proud to say that Maharashtra Medical Council sticks to its timeline pretty well in terms of issuing certificates. And even the additional qualifications have to be registered with the National Medical Council first. We do renewal of registration. I've been told that in the Central Act, there was a mention of credit hours, but the word renewal was nowhere to be found. Now that word renewal has come in. The confusion that happened when this gazette was published was everybody, including me, checked my number and my status in the MCI or the erstwhile NMC IMR register. And what I found also, despite having postgraduate qualification, only MBBS stays. Then we were told that we need to transmit the Maharashtra Medical, every state council, their data up to, in a hard copy and soft copy. We did that as well. And then I and the registrar, Mr. Sanjay Deshmukh, we had reason to go to Delhi for a meeting. And there it was clarified that although the gazette is published, they are still updating their own data. So the next process is not in place as yet. So the message that I want to give out right now is, if your registration of your undergraduation and your post-graduation and super specialization, as the case may be, is updated with the Maharashtra Medical Council, then that is where the story stops. What their plan is, eventually every practitioner in India will have a single unique number, which will be assigned by the National Medical Commission. And on that basis of that number, you apply to the state council to get permission to practice in that region. That is how it's going to work in the future. But right now, although the gazette is in place, none of this has actually happened as a reality. So right now it's at the level of the state council. There's no need to approach the National Medical Commission at this point of time. Next slide. Thank you very much. Thank you. I'll stop screen sharing so that we can.
Thank you, ma'am. Thank you very much for the.
I will like to say a few words.
Yes.
First and foremost, I must say that Dr. Pallavi Sapade Madam, as the Dean of JJ, has handled one very sensitive issue in a very perfect manner. Madam, I have heard your press conference in Marathi and I was very much impressed. Second thing, as you have mentioned that you are going to push certain amendments, I will like to bring to your notice that the Act of 1965, there were 9 elected members. Now, as per your statistics, there are 1,83,000 registered practitioners, but I wonder whether people who have left for heavenly abode, whether their names have been deleted, because renewals have happened only in case of 75,000 or so. So that is one thing. But because in 65 there were hardly 20,000 registered doctors, and now we have so many, so better we have more number of elected members on MMC, and I am sure you will help us in that. Thank you very much.
Yes, that very much is on the anvil. Not just losing doctors to death, but even those who have done their post-graduation in India and moved to other states or moved abroad. We have no record of that. There is no legitimate way
Correct.
where they can come back
And
to us.
secondly,
and
madam, you
that
made
that
these
is the
things
one thing
very
we are
clear.
pushing.
Sorry, you made things clear about the gazette notification of NMC. So we are very happy to note it from you.
Yeah. So that was one point, that is where the missing numbers are. We have 1,17,000 doctors approximately who are active. I mean, at least because last year, 2022 was when most of the people had to renew their registration. So we are pretty updated on that. And 60,000 is a fair number to guess of people who may have moved abroad or moved to other states, who must have done the post-graduation in Maharashtra, or as you said, lost their life. That is very much possible. And the amendment, yes, we're pushing for more members, for more representation, for example, from medical colleges, because right now Maharashtra is the third state in the country to have, I mean, third highest number of medical colleges. We have 67 medical colleges, private, government, of course, and deemed to be universities. So some representation has to come from there, and more representation maybe on a regional basis as well. So we are looking at that, and we're working towards that, hopefully in the next few months.
Ma'am, I'm Dr. Mishra. My only humble suggestion would be, if the representation is worked in proportion to the number of registered medical practitioners in terms of a defined quantum.
Okay.
Because the basis of computation of the representation ought to be in terms of a ratio. And the best ratio is this quantum for one seat. And then that could be distributed in terms of the location geographically dependent upon the revenue divisions that are there in the state of Maharashtra.
Excellent.
Because ultimately numbers cannot be raised without giving a valid correlation for that purpose.
Absolutely.
And the ideal correlation is that it could be worked out in terms of the number of registered medical practitioners located geographically in the revenue division location, whereupon the representations can be worked out. That can mathematically go well, and the logic and rationale of broadening the scope of representation will be duly justified.
That point is well taken, but we've already done that, and I will not take credit for that. That suggestion has come from my registrar and deputy registrar. So we worked out a ratio, a representation per number of practitioners in the region. We've done that already.
Can I add something, sir?
Good evening, madam.
Good evening.
Shiv,
Bol.
Yes, yes.
Safle madam, thank you. Wonderful to see you. Just to add what in continuation with Dr. Ved sir has said, already in 2014-15, this increased representation amendments have been put forth to the government of Maharashtra for one MMC member per 5,000 registrations. And I think you already have that document in your archives, so you can just work on it.
That's
Thank
why
you.
I said I don't take credit for it.
Thank you, ma'am.
Good evening, madam. This is Dr. Utture.
Good evening.
Good evening. How are you? Acha, madam, we have already made a lot of amendments legally as per how the government wants it. I think you are aware of this, and even Sanjay Deshmukh is aware of this. And we have sent it to the government also. I think it would help us if, and in all these aspects have been mentioned in that of increasing in the number of members and everything. So if you could follow it up with the government, because unfortunately we were asked to step down before we could go ahead with, and plus there was a change in the government also. So we could not pursue that. If you could do that, definitely it would help us out. Number two, madam, I think I was a member of the National Medical Commission, and I had vehemently opposed this aspect of National Medical Commission taking over the registration process from the state medical councils. Because let me tell you, the prerogative of registration, health being a state subject, it should always lie with the state itself, number one. Number two, if you see in the MMC Act, whatever finances we get is majority we get it through the state medical council. So when I was there in NMC, we had put it down and they had accepted that though they would go through the National Medical Commission because they want to generate the unique identification number. And I think Dr. Ved sir will also concur with what I have said. We had said that it should be referred to the state council to give the primary registration. Numbers you may give. We don't mind that you giving a number if you want to have a unique number all over India. But the registration process should be the prerogative of the state medical council. And I think you should pursue that also, you being part and parcel now of the National Medical Commission also. Any help you require, you can, anytime you can call me since I'm in Mumbai itself. And even till today, I have got good relations with whoever are sitting there in the National Medical Commission. And we should not lose that powers of the State Medical Council. That is what my submission to you is, madam. Thank you.
We are not. The registration to practice in a particular state stays with us. It only goes to National Medical Council for a unique ID, but they're of course going to charge some fees for it. But
why should our RMPs pay twice to the State Council also? And I'll tell you, National Medical Commission gets enough of finances, huge finances. I was there, I know how many crores they have. So why should our doctors pay twice? And it should be left to the state councils. That is what I'm trying to tell you.
I'll note it and I'll see if, I can.
We have a couple of questions. Dr. Arshad, sir, if there are any questions from the delegate.
Yeah, sure. Thanks.
Yes.
First thing first, thank you very much, Dr. Saple. I think you did a very elaborate job, a very exhaustive job, and helped the audience understand the finer points of the Maharashtra Medical Council Act of 1965 and the rules that were laid down in 1967. Just a stray thought before I come to a very pointed question. And the stray thought is about the amendments. I'm very glad that you, as the administrator of the Maharashtra Medical Council, understand that there is a strong need for reforms or strong need for amendments in Maharashtra Medical Council Act. If you look at the history of amendments, I think the first time any amendments were brought to MMC Act was in 1967, just 2 years after the Act was promulgated. The second set of amendments were pushed in somewhere in mid-70s, and the last set of amendments were done in 1984. And since then, we have had no amendments in Maharashtra Medical Council Act. I'm sure you will appreciate that no law is ever written in stone. No law is ever etched in stone or cast in stone. So that definitely with passage of time, with passage of difference in values, there is always scope for bringing in amendments or reforms. One set of reforms which Dr. Uttare talked about, the others talked about, and which I appreciate even you understand and are trying to enforce, is of course the composition of the medical council. And the fact that the elected representatives are never in majority. It is the other non-elected members who seem to be ruling the roost when it comes to running the council. And here I would suggest that you can refer to the Bar Council Act, or you can refer to the Chartered Accountants Council Act. That will give you an insight into how they run their councils. For example, if you look at the Bar Council Act, all the members of the council are elected except one. And that one is the ex officio position held or reserved for the Advocate General. Now compare that with the kind of council we run in Maharashtra. Just 9 elected representatives, and sometimes more than 9. Last council only had 18 members, but earlier we have had 22 members also in the council. And we still had only 9 elected members. So I think there is, the democratic values demand that we kind of correct this imbalance. So if you're working in that direction, it's really a very welcome step.
So
Secondly,
running short of time, sir. We're running short of time. We have 2 more sessions.
Well,
Yes.
in that case, a very quick and a pointed question to you, Dr. Saple, before we sign off. You are the extension of the ministry as far as Maharashtra Medical Council is concerned. And as an administrator, I'm sure you appreciate that it's just a stopgap arrangement. We need to have elections and install a truly representative Maharashtra Medical Council. So can you give us an idea to the audience as to when do you intend to hold the Maharashtra Medical Council elections?
In fact, I've been working on it since the day I joined, but the first thought that came to me is, I went through the act as well. Stating this very briefly, maybe we could take it up some other time, is we need to go, I'm a pediatrician by training. So most of the associations now have an online system of elections, and I've checked through multiple stakeholders to realize that it's reasonably foolproof. So that is what we have proposed to the government, that kindly move to an online system, because when the last election happened, I was a dean at Sangli, and I realized that only the local people from, even if it's a district place, in Maharashtra, some districts, some talukas are 70 to 90 kilometers away from the district place, and it doesn't happen. So if we want, and it was only, I believe, close to 30% participation in the last election. If we want to increase it, we need to go to some foolproof method, which is online. Everybody has a smartphone. Today, you don't need a smartphone. So that is what I'm trying to do. And I've put that proposal a few months ago. I'm waiting for the assembly session to get over. That is when I'm going to start pushing for lots of things.
So do we have a
Thank you,
timeline
madam.
in mind
Thank you, madam.
as far as the next
No,
election is
I
concerned?
think, I think,
Yes, we'll,
No, no, 1 minute, 1 minute.
ask-
Archana,
Yes,
Archana,
yes,
1
sir.
minute. We missed the introduction of Dr. Arshad Gulam, who is responsible for converting the corrupt postal ballot to physical ballot. This is a very important step, and he was the person who has gone to court, Bombay High Court. We have missed that. And secondly, I must thank and inform the audience that 23rd August is the hearing for the case where IMA is pressing for early elections. Thank you very much.
thank you, sir. Thank you so much. Thank you very much, Dr. Pallavi.
Thank you.
Very
It was
informative
very helpful.
lecture and very interesting.
Madam, you have really, Meena, I'll just interrupt you. Madam, you have been really great, informative, and you have really given the information in, a great nutshell, but given everything at a glance. And yes, there are concerns about, when the elections will take place or how the things will take place. But we also understand that you can very well take the message to the government, and that is the reason, even though you are not the person who's going to be holding the elections, these questions are being directed at you. So we hope you take it in the right spirit. And with this, I request Dr. Meena to take the session forward.
Thank you, Dr. Archana. We would like to present on behalf of IMA Dombivli. We would like to present a certificate of appreciation to Dr. Pallavi Sapre for the comprehensive and elaborate session for medical professionals on MMC Act and Rules during the online Medico Legal Let's Act Summit organized by IMA Dombivli on Saturday, 29th July 2023. Thank you very much, ma'am. With this, I thank the
Thank you very
chair and the
much. Thank you.
co-chairperson, Dr. Pingle, sir. Thank you. Thank you, Dr. Arshad. Over to you, Dr. Archana, for the next two sessions.
Thank you so much, Sapre Madam. Thank you very much, Pingle sir, and of course, Arshad Gulam sir. And sir, we really missed on that introduction because I think many of us were not aware of the introduction which Suhas Pingle sir gave. And thank you, Dr. Pruthi. And we move forward. By moving forward, I first apologize to Mishra sir, Vankadkar sir, Deshpande sir, and of course the speakers after that for the delay in the sessions which is happening. Without wasting time, we move on to the next session. We as medical professionals are expected to be moral, ethical, empathic, compassionate, maintain certain decorum, conduct ourselves in a certain way which suits our profession, and also follow certain professional etiquettes. Professional misconduct, breach of ethics and etiquette makes us liable to disciplinary action. Medical practitioners have to abide by Indian Medical Council Professional Conduct, Etiquette and Ethics Regulations 2002. And to make us understand in detail about the IMA regulation, IMC Regulations 2002, we have with us a speaker par excellence, Dr. Ved Prakash Mishra, sir. It is an absolute honor to have you with us in the summit today, sir, and thank you for joining the summit. To chair the session, we have past National President, Dr. Ravi Vankadkar, sir, and to co-chair the session, we have past President IMA Maharashtra State, Dr. Y.S. Deshpande, sir. And to chair moderate the session, I invite upon past President of IMA Dombivli, Dr. Makarand Ganpule. Over to you, Dr. Ganpule. Dr. Ganpule?
Actually, it's an honor to introduce the stalwart personality, Dr. Ved Prakash Mishra, Professor of Excellence, Professor of Eminence, and Professor Emeritus. Dr. B.C. Roy, National Awardee, BSc Honoris Causa by 7 universities, National Head of Academic Program of Indian Program, UNESCO Chair in Bioethics, Haifa, and member of International Committee for Bioethics for Asia Pacific region. Chief Advisor to Honorable Chancellor at Krishna Institute of Medical Sciences, Karad. Pro-Chancellor Datta Meghe Institute of Medical Sciences, Nagpur. Advisor Human Ethics Committees, Association, Bangalore. Honorary Director, Center for Health Sciences, Education Policy and Planning, DMIMS, Nagpur. Former Vice Chancellor, Datta Mege Institute of Medical Sciences. Former Chairman, Postgraduate Medical Education Committee, Medical Council of India, New Delhi. Former Chairman, Academic Council, Medical Council of India, New Delhi. And 96 registered copyrights in domain of medical education. So ladies and gentlemen, please welcome Dr. Ved Prakash Mishra. To chair this session, we have Dr. Ravi Wankhedkar, MBBS, MS, FIA, MS, FCGP, practicing surgeon and anorectal surgeon for last 30 years. Honorary Professor of Surgery, Government Medical College, Dhule. Past National President, Indian Medical Association. Past Treasurer, World Medical Association. Past National Secretary, Indian Medical Association, Hospital Board of India. Ex-member, Maharashtra Medical Council. Ex-member, Board of Examination, MUHS Nashik. Past National Chairman, IMA AMS. To co-chair this session, we have Dr. Y.S. Deshpande. Dr. Y.S. Deshpande is past President of IMA Maharashtra State, past President, Indian Medical Association, Nagpur, past Vice President, Indian Medical Association, Maharashtra State, recipient of National and State Award as the Best President, past Secretary, past President of Association of Surgeons of India, Nagpur, regular CWC member, IMA headquarters since 2007, past President of Rotary Club of Nagpur, Green City, Ambassador against sex selection by IMA headquarters, New Delhi. So please, I request our chairperson, Dr. Ravi Wankhedkar, sir, to please welcome Dr. Ved Prakash Mishra, sir, and request him to start his session.
Thank you, Mac, for the kind introduction. Before I do my assigned job, let me congratulate IMA Domboli for their golden year celebrations. And I really appreciate the wonderful organization of this conference, Let's Act, which is going to be highly useful. The President, Dr. Vijaya Lakshmi, Secretary Archana Ben, Treasurer Hemant, Mac, Nita, and of course the dynamic, my Bandhu, Dr. Mangesh and Archana Ben, who have transformed IMA Domboli from a small sleepy branch to a very vibrant active branch. My humble suggestion, Archana Ben, would be such important topics have been delivered, have been tackled, and so many answers have come out. My request would be compile all this and publish a small handbook or a small white paper sort of thing where on each particular topic, our members can have a ready reckoner, whether we need to register under Shop Act, whether we need to register under NMC. So all this will be for posterity also, and it will be very helpful. Coming to today's topic, very nicely that in continuation with the Maharashtra Medical Council, we have with us the doyen of medical education regulations in this country, whom I always referred as the fifth Veda. We know only of 4 Vedas. And the fifth Veda of medical education in this country, who knows each and every dot, comma, all, not only the grammatical functions, but the connotations, denominations, hidden meanings of all the regulations related to the medical education in this country. Very rightly, IMA Domboli has chosen and requested Ved sir to deliver his talk on the ethical rules and regulations, not only of 2002, but the recent regulations notified by NMC, which are practically a copy of the MCI regulations. So without further ado, may I request the fifth Veda sir, Professor Ved sir, to deliver his talk. Over to you, Ved sir.
Thank you very much, learned chairperson, and a very darling brother to me, former president, national president of Indian Medical Association, and former treasurer of World Medical Association, the roles in which he has stamped himself as a person of eminence and consequence both. Esteemed Professor Dr. Ravi Wankhedkar, learned co-chairperson with whom I have the association which dates back to from my undergraduate days from 1974 in Government Medical College, Nagpur, and from there to my learned younger brother, Dr. Y.S. Deshpande, my esteemed colleague and a friend, Dr. Mangesh Pate, Dr. Archana Pate, all the members of the organizing team. I join the learned chairperson in complimenting IMA Dombivli branch for this very notable initiative and titling it under the rubric of Let's Act, which per se gives the polemics of the actions required to be undertaken out of the various spheres that affect the medical profession and the professional. Chairperson, sir, with your concurrence, in terms of the theme which is contemplating Code of Medical Ethics Regulation 2002, I think the provisions of the regulation which have been put across have been in operation from 2002 till date, with an interim repeal and modification by the National Medical Commission notifying it in 2022 all over again. I would like to primarily focus on two important things, Chair. Why Code of Ethics? What's the basis of it? And then on the inclusions of Code of Ethics in terms of the principles that internationally evolved over a period of time. Constitution of this country, Chairperson, authorizes every citizen in terms of a right vested in him or her under Article 19(1)(g) of the Constitution of India, whereby he or she is entitled to earn a livelihood and a living for himself or herself, resorting to 7 important modalities which are prescribed under the Constitution. You and me are entitled to be earning our living either out of trade, commerce, calling, order, occupation, vocation, or profession. Of the 7 modalities, the 7th modality which is put at the end is profession. Therefore, we will not be able to understand the relevance of Code of Medical Ethics, which is mandated for a profession and not for any other mode of living, is on certain considerations. We need to understand a distinctive line which separates an occupation from a profession. All professions are occupations. But Chairman, sir, all occupations are not profession. Now, this is the dictum. If we are able to decipher, I think the entire scope, mandate, relevance, authority, jurisdiction, intent, purport, objective, operation, outcome, enforcement, and discipline, which turn out to be the 11 parables for any regulation to be put into operation, we would be deciphered without any difficulty. An occupation gets converted into a profession subject to fulfillment of 3 important preconditions incorporated therein. Number 1, an occupation can be converted into a profession if there is a structured program which is meant for teaching, training, orientation, results in an end certification, bringing out authority now to practice in terms of gained proficiency. When I speak for medical profession, Chairman, sir, it is the MBBS qualification which is required, which is designated as registering medical qualification across the world. MBBS qualification is earned through a structured program that is called as MBBS curriculum, MBBS syllabus, MBBS training, teaching duration, progression, and end certification in terms of a degree which is conferred by the examining university. Therefore, the first requirement is end certification arising out of a structured program. In case of India, the academic qualifications can be conferred only by a degree. And the Indian Medical Degrees Act 1916 was the first act which was put across by the British Parliament, whereby the Indian medical schools were in a position to confer Indian medical degrees, including MBBS qualification, to Indian medical graduates. However, the second requirement of profession is that this structured qualification should be entitling him or her to be registered so that the name of the person is included in a register created for that purpose. And therefore, there has to be a statutory registering authority vested with the authority and jurisdiction of maintaining the record of the concerned register including the names of the registered medical practitioners in case of medical profession incorporated thereunder. From 1916, in spite of the fact that we were entitled to confer the degrees from Indian medical schools to Indian medical graduates, but registration was not done in Indian statutory authority. It was under General Medical Council of Great Britain. And therefore, in the year 1934, the first Indian Medical Council Act, which was adopted by the British Parliament, which came to end up in resulting a creation of Indian Medical Council, authorized to maintain an Indian medical register. Therefore, the requirement of registration from General Medical Council of Great Britain stood vested with the Indian Medical Council created under Indian Medical Council Act 1934, which ultimately, upon the recommendations of Radhakrishnan Commission, First Education Commission constituted in Free India, which ended up in creation of Indian Medical Council Act 1956, repealing the 1934 Act, and therefore Free India got its Indian Medical Council in the year 1956 for the purposes of maintenance of Indian Medical Register, incorporating therein the names of Indian medical graduates who are entitled to practice medicine. Second requirement. The third requirement, Chairperson, is that the conferment of the privileges for the practicing of profession by the registering authority are not blind, are not blanket, and are not absolute. Therefore, they are provided, they are furnished in terms of explicit embargoes which are authorized to be incorporated thereunder. Therefore, the third requirement of profession is that it will be practiced within the tenets of reasonable restrictions or embargoes which will be prescribed by the registering authority, and the entitlement of the inclusion of the name in the register will mandate adherence to those particular restrictions imposed. As occupation of medical science is governed by these three prerequisites in the form of qualification through structured proposition, the statutory authority for registration, registration being conferred for the purpose in terms of conferment of privileges to practice medical profession by the registered medical practitioner, and the reasonable restrictions which are imposed are in the form of ethical conduct, moral conduct, and value ethos. This did not generate just like that. I am not taking into the entire historicity from the pre-AD age. I am just wanting to bring important landmarks which have to be taken note of to be able to decipher this topic with clarity. Chairman, sir, it was the horrors of Second World War, especially incorporated in Nuremberg trial, especially the role of doctor community in the entire domain of Second World War under the aegis of Hitler, where the world saw the killer face of the doctors, including the absolute misuse and inhuman use of the prisoners of war, the horrors incorporated in camp number 783 in China by the Japanese forces, all that brought out a very ugly face of breach of what we call as inhumanistic conduct of medical profession. The healers revealing the face of they being worst killers. The biomedical research which was carried out then was perhaps most unhuman in nature and character, and therefore, Chairman, sir, horrors of the Second World War made the entire world to regroup together and give a new lease of thought for the purposes of a new world order in order to make this planet a better habitation for the entire human race. And therefore, without dragging further, I will straightway bring you to 1948, where the entire world congregated to generate what is called as UNO Declaration, forming United Nations Organization. Hats off and salutations to the body which you represented as a treasurer and as a member of executive committee for several terms. Chairman, sir, it was this World Medical Association in the year 1948 took up the cause of United Nations Organization Declaration, which we call as Geneva Declaration. London, it meant in 1948. Out of 4 days critical deliberations, it evolved in what is called as Geneva Convention. Chairman, sir, Geneva Convention within its reference has got 2 mother documents. And the first mother document is International Code of Ethics, which was generated, which was referred by WMA, availed as a basal document for incorporation of something vital and necessary in terms of bringing out what is called as Geneva Convention. And the second important document was International Guidelines for Human Justice, second document, which was again referred as a referral document. Chairman, sir, biomedical research document was not entailed in Geneva Convention. Therefore, it was in the year 1964 that WMA and UNO Charter met together in Helsinki, wherein the Helsinki Declaration came to be generated in the domain of biomedical research, which read with Geneva Convention makes the entire gamut of code of medical ethics, etiquettes, behavior, and other propensities that are applicable as reasonable restrictions or embargoes attributable to practicing of the medical profession by the registered medical professional in terms of the privileges extended to him by the registering medical council. Speaking for your and my country, federalism being the basis of constituent proposition under the constitution, the registering authority which we are discussing was vested with the state, health being a state subject in terms of the charter incorporated in the list of subjects allocation, and therefore state medical councils created by the state enactment were given the authority of generation and maintenance of the state medical register, and the mechanical transfer of the state medical register annually resulted in generation of the national register, a position which is being reversed now for reasons best known. I am not touching on that. What I am wanting to touch on is, Chairman, sir, the reasonable restrictions which came to be generated is not an accident, is not an aberration. In order to bring the humanistic phase of the medical profession, and in order to bring out the socialized nature that should be built in the practicing of medical profession, therefore the two arms of code of medical ethics in terms of feeding units are called as humanization of the profession and socialization of the professional. Therefore, the two arms have to be interwoven to bring out a sort of conduct which will be conducive, which will be illustrative, which will be exemplary, which will be confidence building, which will be inspiring, which will be humanizing, and which will be catering to the cause of socialization of profession. It was with these 7 objectives that the entire concept was framed. However, position from 1956 Act till 1997, there are certain important things which have to be borne in mind. Till 1997, the Indian Medical Council was only in a position to make guidelines, not in the form of recommendations. But these guidelines which were put across were neither mandatory nor binding in character. It was in the year 1993 with incorporation of Section 10A, prescription of the subjects which are to be governed by regulations, regulation subject being included in Section 33, rules being incorporated in Section 32, and in 1997, a historical battle in the Supreme Court, wherein the Honorable Supreme Court ruled that the regulations which will be prescribed by the Medical Council of India in regard to the subjects included under Section 33 with the prior approval of the Government of India will be binding in nature and mandatory in character. Therefore, from 1998, the era of binding and mandatory regulation comes into operation within the ambit and jurisdiction of Medical Council of India, and therefore 5 important regulations wherein I had the privilege and fortune of being a first party incorporated therein begins from Graduate Medical Regulation of 1997, Minimum Standard Requirement Regulation of 1998, Minimum Standard Requirement commensurate with the annual intake 1999, Postgraduate Medical Regulation of 2000, and Code of Medical Ethics Regulation of 2002, resulting in completion of the list of entries incorporated in Section 33. And the delay was not at the level of Medical Council of India. The delay was at the level of Her Highness, the Government of India, who used to sit, and the gestation period of the approval granted was on an average 1 to 2 years. Therefore, in the period of 1997 December judgment, as 1997 December judgment, the spectrum of the regulations got completed in the year 2002. Of course, they were subjected to modification depending upon the needs of time. Therefore, the guidelines which were governing the medical profession till 2002 got converted into a frame of an operational reference, which is called as a Regulation on Code of Medical Ethics in the year 2002, which brought binding and mandatory effect in terms of regulation of the medical profession within the tenets of ethicality, morality, and valuitas. What is exactly significance of 2002 regulation? Time at my disposal is short. Therefore, I'm just briefing it across. Three important things should be noted. Number one, it mandates in terms of the code of ethics itself vis-a-vis a declaration. It begins with a declaration. And what is the declaration about? Declaration is about that every registered medical practitioner will be given a copy of this particular regulation at the time of registration and a document which is Appendix A, which is nothing but Geneva Declaration in its 16 clauses, which now is amended to 17 clauses in terms of Philadelphia Declaration of 2017, making it 17-clause charter, which we call as oath. And therefore, he is a signatory to the oath, and that oath contemplates adherence to this book called as Code of Medical Ethics. Therefore, this becomes the Bhagavad Gita for the purposes of practicing of the privileges of the medicine conferred upon a registered medical practitioner within the tenets incorporated thereunder. Second important thing is that it brings out very candidly a significant feature, and that is depicted in clause 1.1.3. And that is, who is entitled to practice, entitled and conferred with the privilege of medicine? One who is in possession of duly recognized registering medical qualification alone. Restriction is explicit. Nobody else is entitled to practice modern medicine other than the one who is qualified in terms of the conferment of that particular qualification, therefore is entitled to get his or her name included in the register, and therefore is entitled for the conferment of privileges, and therefore it is only he or she who is entitled to practice modern medicine. Therefore, people say where it is written. I am wanting to bring it out to very clearly. It is not a provision in the Act. It is the mandate which is incorporated in terms of the Code of Medical Ethics, which is having a binding nature and mandatory character, puts the scope, and therefore, just as mandate is declaration, scope of the regulation is this particular exclusive privilege only to people whose names are incorporated in the state medical register. This far and no further is the emphasis which I am wanting to bring out to. As Chairman, sir, because the inclusion is explicit and the exclusion is restrictive, the force of this document becomes of the highest value. Hence, when it is only a select class of people who are entitled to be practicing these privileges, and there cannot be any admixture. If the admixture of the practicing is not there, sir, admixing of the teaching learning is equally not possible, because admixture at the level of Gangotri will be resulting in an admixture at the level of Ganga Sagar in totality, which is neither open nor permissible. Therefore, when people talk of where mixopathy is to be not permitted is written, I'm just pointing out it is here, and it is here. Having said so, just briefing about the code part of the medical ethics, maintaining good medical ethics, maintaining medical records, display of the registration numbers, use of generic names of medicine, highest quality assurance of patient care, exposure to exposure of unethical conduct, payment of professional services, evasion of legal restrictions, duties and obligation to the patients put across in clause 2, obligations towards the sick, patient's delicacy and secrecy as a hallmark of operational practice, prognosis as one of the modalities to be incorporated thereunder, patient cannot be neglected being the essence of operation, including a specific clause for engagement of an obstetric care, goes into indicate the scope and mandate of services in terms of the profession. Chapter 3 deals with duties of the physician in consultation, which brings out that unnecessary consultation has to be avoided. Consultation for patient's benefit alone is the entitlement. Punctuality in consultation is hallmark of the operation. Statement to the patient care after consultation as a mark of respect to the autonomy of the patient. Treatment after consultation, beneficiaries being incorporated, the governing principle, patient being referred to specialist in terms of the conditions incorporated thereunder, and chargeable fee and other charges being worked out in specific clauses. Chapter 4 dealing with responsibilities of physicians to each other in terms of professional conduct with colleagues. Chapter 5 bringing out duties of physician to the public and to the paramedical profession. Chapter 6 bringing out the nature of the unethical act depicting advertising, patent and copyrights, running it to open shop, dispensary and drug appliances by physicians, required the aspect of rebates and concessions, including abandonment of secret remedies, emphasis on human rights, and a clause which is specifically pertaining to euthanasia. 2009 important amendment which was brought in the Code of Medical Ethics was relation of the professional with pharmaceutical and health industries. And that relation as to how exactly is required to be governed in terms of the conduct is incorporated in Chapter 6. I am not going into the details, but the good part of it is not only exhaustively described, but for the first time in any regulation, a new experimentation which was brought out in this regulation in 2009 was made illustrative, because the nature of the punishment commensurate with the wrong in regard to professionals seeking the unauthorized benefits vis-a-vis the pharmaceutical industries is brought out, and its catalog in terms of entire 6.8 and thereafter. And one more important aspect which is incorporated in this particular clause is not just limitation to profession, but even biomedical research aspect is covered in the Code of Medical Ethics and Regulations. I am giving you a brief outline into this entire because this is the coverage of the regulation. All of us are well aware as to what are the inclusions are therein. I am not illustrating on them. But the concluding part which I am wanting to put across is, ladies and gentlemen, there are paradigm changes which are taking place. Basic rules which govern the Code of Medical Ethics were constant, are constant, and would be constant. The 4 cardinal principles on which the nobility, operability, effectivity, and the elegance of profession, which always was tested, is tested, and will continue to be tested, will be the principles of beneficence, non-maleficence, autonomy of the patient, and justice, including esteem, honor, dignity, and equity. These are uncompromisable principles. But yes, there are areas, advent of various prepositions which are taking place over a period of time, advent of science and technology at a pace which is galloping in nature, artificial intelligence dominating at our doors, incorporation of telemedicine turning out to be the way of modality, euthanasia by itself in terms of the cultural moorings and leanings turning out to be one of an important area, robotic medicine itself raising a head of challenge for the purposes of structuring of ethics, and therefore, in spite of its core principles remaining what they ought to be, the dynamics in terms of demographic, cultural, socio-economic, and technological changes mandate that the document needs to be updated not only in terms of contemporary changes and challenges, but also the long-term challenges and long-term concerns. It is for this reason advocating that time has come where we need to take this up for yet another fresh consideration and bring out the remedial changes which are necessary to be tackling the contemporary challenges and also futuristic requirements into me. I know my time is short, but therefore I'm trying to sum it up in a capsulated manner as best as I could, wanting to bring out the prologue as to how we need to decipher the scope, relevance, and significance of Code of Medical Ethics as a regulation. Thank you very much, Chair, for giving this time. I'm obliged to the organizers and both to the chairperson and learned co-chair. Thank you very much.
Thank you, Dr. Vedak Prakash Mishra, sir. Over to Dr. Y.S. Deshpande, sir, to take if there are any questions in the audience.
Yeah, I consider it as my honor to be chairperson, to be co-chairperson for the talk of Dr. Ved Prakash Mishra, who is, of course, a star speaker, pride of Nagpur, Maharashtra, and India also. His encyclopedia in acts and regulations related to medical practice and medical profession. Why encyclopedia only in medical profession? Any topic given to him, He is an encyclopedia, I would say. And as always, he has mesmerized all of us on his narration of IMC regulation 2002. Now, sir, my only question to you is, like a lot of amendments were there in this IMC regulation, 1964, 1993, and as you said in 1997, 98 also there were amendments which were made, and 2002 regulations were there. Now, as reformatory measures to amend this regulation, National Medical Commission on 23rd of June 2022 had put this in a public domain, this draft of these regulations, as you are aware of that. Now, my question is, what is the relevance of 2002 now in 2023 and by NMC? That is my question, because as you have already said that there are a lot of things were covered in this 2002, and so whether that continues and what is the relevance? That is my question, sir.
See, as of now, if you really ad verbatim compare, Dr. Co-Chair, the regulations which were notified in 2002 and the regulation which is notified in June 2022, it is put in public domain. Till that point of time, this regulation was in force. I do not find, and subject to correction by Dr. Utture, because both of us have looked them very critically, there is nothing which has been added in terms of anything new or novel other than what was there in 2002. And 2002 was amended in 2009, as I'm telling you. So therefore, I say 2009 regulation, precisely we may call it. There is hardly any change which has been brought in terms of the original regulation. And therefore, what was the need for repealing it, I do not understand. But maybe that was an exercise which was required to be performed, but that exercise has not brought anything new or novel. I do not know, even they have not revealed what were the suggestions which were received when the draft regulation was put into public domain. And therefore, it is very difficult to say what is new in 2023 regulation, 22 regulation. In my humble opinion, it continues to be an ad verbatim extension of 2002 regulation amended in 2009 without any further amendment of any type incorporated thereafter.
Because as they are registering the graduates from other pathies also in this, so that is against against what you have shown.
That was the reason I am telling you, because the clause 1.1.3, whether it was in 2002, whether it was in 2009, or whether it is in 2022, it continues to be there. And therefore, you read that clause and you will be realizing that embargo is very explicit. The person with qualifications duly conferred in the domain of modern medicine by the competent designated authorities will alone be registered, and they alone will be entitled to be conferred with the privileges of practicing modern medicine. So it is not only loud and clear, but the restriction is explicit. This far and no further. Now, in the teeth of that, what is not provided for in the ambit of the parent clause, how a schedule can be modified to incorporate any other thing, is something which is difficult to decipher and hard to digest. Hence, my very categorical opinion, and not only my opinion, pronouncement made by the Honorable Supreme Court in 1986 judgment, in 1993 judgment, in including a reiterative judgment which has been given in the year 2011, they speak that privileges of modern medicine can be practiced only by a person who is duly registered in the state medical register or the national medical register by virtue of having requisite prescribed registering medical qualifications under his or her belt.
Thank you so much, sir. If there is any other questions, one or two questions can be entertained.
Yeah. Dr. Utture sir wants to ask some.
Yeah. Thank you, Ved sir. As usual, explicit in your this, and no wonder we still call you the Panditji of medical education and ethics. Very elaborate, you have said. And just to further to what Ved sir said and answer Dr. Y.S. Deshpande, as of today, 2002 Code of Ethics is in existence, because the new, it is still in the draft stage. It has not yet been notified at all. And second thing is, even in the draft, if you see, we were sitting there in NMC, and luckily for me. I was part and parcel of the core ethics committee, the committee which was making these modifications. And at that time, I was in continuous contact with Dr. Ved sir also. We have seen to it that nothing is changed from the 2002 document. Only thing is, the only change that has come is that just like how in 6.8, as far as the pharmaceutical this is concerned, you have quantumized the punishment. Same way in this new draft, it has been quantumized because different state councils were giving different type of punishments. So that is the only major change which has taken place over here. My one question, Dr. Ved sir, would be, and which also I have been fighting in the National Medical Commission, is that we are a quasi-judicial body. Both the state councils and the National Medical Commission are quasi-judicial body. And yet in National Medical Council today, when our doctors are pulled up for this ethics, half of them are so scared to go there, because I get many phone calls of what we should do going there and everything. But they do not allow the lawyers to be there to represent them. They said the lawyers come and sit with you and assist you, but they cannot talk in National Medical Commission. So we just wanted your views. If we are calling ourselves as a quasi-judicial body, why do not we allow our doctors to be represented by some medical legal expert over there? I think he will be able to defend himself much better. That was my only question, which I've been fighting with NMC also.
Dr. Uttara, you're well aware that entitlement of any applicant before any judicial or a quasi-judicial authority is vested with only two persons. A, either the person self as a self-defense, and second is by his authorized agent. And the most suited authorized agent in terms of profession is a lawyer. I am still not in a position to find anywhere in an explicit exclusion that lawyers are not permitted to appear before the State Medical Council or National Medical Commission. There is no explicit embargo. And the second thing is the restriction that lawyers will be assisting but not arguing is absolutely an untenable, hypothetical, and unacceptable proposition. You cannot be saying that you will be sitting over here and but not opening your mouth for argument. See, you have to be not only equitable. A quasi-judicial tribunal is expected to dispense its role on three counts. A, it has to be equitable. B, it has to be just. And C, it has to be fair. And if you are putting any restriction, the restriction has to be tested on the grounds of reasonability. Therefore, the restriction that you are talking is absolutely arbitrary, untenable, and absolutely is imaginary and fictitious. It cannot stand. Either the person is permitted, but the question is, if I am permitted to be represented by my agent, then it is the discretion of the adjudicating authority to permit both the valid agent and self. That is your discretion. There you can take a position, either you or your authorized agent. But to say you and authorized agent in a marginal way absolutely is illogical and irrational. Therefore, in my opinion, and in absence of any explicit embargo, any client before the quasi-judicial committee or tribunal of State Medical Council or National Medical Commission can be represented either by self or by his authorized agent, who could even be a non-lawyer and per se a lawyer as well.
Thank you. Thank you.
May I request?
Thank you, Matt. Yes, want of time. We will take the questions later on. We can contact Ved sir anytime. Thank you, Ved sir, as usual, for a most informative, most eloquent, and you are really not only an encyclopedia, beyond encyclopedia. Two things I will just like to summarize. One, sir did very rightly mentioned about the origin of Code of Ethics, International Code of Ethics, which is the basic repository or the Geneva Declaration. And very rightly, sir has enunciated the basic tenets of ethics remaining constant. Ethics is always a living document. It has to be dynamic, to be adapted as per the situations arise. And accordingly, World Medical Association, which I am very proud of, was associated for 4 years, and part of the core committee of ethics, which we reevaluated every 10 years. We reevaluate the Geneva Declaration or the International Code of Ethics. And last year in 2022, after deliberations and discussions for over 2 years, the latest International Code of Ethics was passed in now called as the Berlin Declaration, wherein it is everyone is requested. You can just go on wma.net. Important one addition which I would like to mention: first time International Code of Ethics is talking about the rights, privileges, and safety of the physicians also, which unfortunately was not there in the Medical Council Ethics of 2002-2009, and definitely it is not there in the NMC of 2022. The National Medical Commission is missing out on a chance, golden chance, of consultations and taking inputs and implementing of all the stakeholders to make it as a living document, updated document, wherein we find that going by the anti-democratic, anti-student nature of the National Medical Commission, nothing expected out of it. The second point about mixopathy, very rightly, even if the MCI Code of Ethics has it, now the government is very cleverly, or the National Medical Commission is very cleverly, under the garb of integrative or holistic medicine, is introducing all the pathies within the curriculum itself. So the Indian medical graduate, which Dr. Ved sir envisaged to be an international medical graduate, is going to be an integrative medical graduate. And thereby they will allow him to register in the National Medical Commission register, so that we will have a mixopathy in a different form. So this was the just two more points. Once again, thank you, Ved sir. Thank you, Y.S. Deshpande sir, my senior surgical colleague. And once again, congratulations, team IMA Dombivli and Mangesh. Thank you.
Thank you, organizers. Thank you.
I
Dr.
think
Kabir Wankelkar, sir.
I think Mishra sir has left the summit. He had another meeting at 5:30. So on behalf of IMA Dombivli, I take this opportunity to thank Ved Prakash Mishra sir for, he waited for the session, even though he had told me very precisely that I'll join at 5 and I'll leave at 5:30, because till 5 he had a meeting and at 5:30 he had another meeting. But then he waited and he delivered his session in the summit. And we are really grateful to sir for that. And thank you so much, Wankelkar sir, and thank you so much, Deshpande sir, for chairing and co-chairing the session. And with this, even though sir is not there, on behalf of IMA Dombivli, we show our gratitude to Ved Prakash Mishra sir for his presence and taking this elaborate session. And we will definitely be sharing the certificate with sir. So with this, thank you so much, Dr. Ganpule, for moderating the session. And we move towards the last session of the day. And the speaker and the chair, co-chair again are waiting in the session for a long time. We apologize for the delay and thank you for waiting out. So when it comes to health, the term health is no more related to physical aspect of the body, but also includes mental and spiritual well-being. The Mental Healthcare Act 2017 has a history of originating in the earlier act, the Mental Health Act of 1987. This act empowers accessibility to mental health services for all. This right is meant to ensure that services are accessible, affordable, and of good quality. It also mandates the provision of mental health services be established and available in every district of the country. And to talk about Mental Healthcare Act, we have with us Dr. Hemant Sonanis. Warm welcome to the summit, Dr. Sonanis. To chair this session, we have Dr. Santosh Kulkarni, and the co-chair for this session is Dr. Kush Junjunwala. And to moderate this session, we have our own eminent psychiatrist of Dombivli, Dr. Vijay Chinchole. So over to you, Dr. Chinchole.
Thank you, ma'am. Good evening, everyone. So to talk on a very important act of related to right of mentally ill patient as well as ethical guidelines for those who are dealing with mentally ill patients, that is Mental Healthcare Act 2017, we are having eminent speaker, Dr. Hemant Sonanis, sir. Dr. Hemant Sonanis, sir, is a practicing psychiatrist. He has completed MBBS, DPM with gold medal, and MD in psychiatry with gold medal. He is practicing at Manoday Clinic, Mind Care Clinic and Counseling Center and Sunshine Counseling and Therapy Center in Nashik. He is the chairman of IMA Maharashtra State Mental Health Subcommittee. He is executive committee member of Indian Psychiatric Society West Zone branch. He is executive committee coordinator for Mental Healthcare Act and legal committee of IPS Indian Psychiatric Society West Zone. He was past president IMA. He is past president IMA Nashik, past honorary secretary Academy of Medical Specialties IMA Maharashtra State, ex-lecturer in psychiatry Vijay Medical College and Sassoon Hospital Pune. Sir is guest speaker at various national and regional level conferences. He writes regular articles in newspaper and magazine on various sensitive issues related to mental health. So he is doing a lot of work for the awareness of mental health. To chair this session, we are having Dr. Santosh Kulkarni, sir. Sir is a consultant ophthalmologist at Atharva Eye Hospital and Laser Center, Kurdwadi in Solapur district. He is past Joint Secretary IMA Maharashtra State, past Chairman PC PNDT State Committee IMA Maharashtra State, past Chairman State Medical Legal Committee IMA Maharashtra State, past Chairman State Anti-Quackery Committee IMA Maharashtra State, past CWC member, past member of Indian Medical Association Headquarter Anti-Quackery Committee, received IMA Maharashtra State and my IMA Headquarter felicitation and appreciation many times. To co-chair the session, we are also having the eminent personality, Dr. Kush Junjunwala sir. He is practicing pediatrician at Nagpur. Also, sir is an associate professor of pediatrics at Government Medical College, Nagpur. So, I request today's chairperson, Dr. Santosh Kulkarni sir, to welcome our eminent speaker for the session. Over to you, sir.
धन्यवाद डॉक्टर चिंचोळे सर. हॅलो.
Hello. Yes, sir, you are audible.
हा, धन्यवाद डॉक्टर चिंचोळे सर. सर्वप्रथम मी सर्व जे पार्टिसिपंट आहेत त्यांचं मनपूर्वक अभिनंदन करतो, कारण मानसिक स्वास्थ्य अत्यंत महत्वाचा विषय आहे आणि शेवटपर्यंत जवळपास 250च्या वर आपले पार्टिसिपंट आज आपल्या ह्या लेटेस्ट ऍक्टल्या कॉन्फरन्सला उपस्थित आहेत. माझे मित्र डॉक्टर हेमंत सोनानीस विजय मेडिकल कॉलेजचे एक उत्तम आणि प्रसिद्ध सायकॅट्रिस्ट आहेत नाशिकचे, आणि एक सामाजिक भान असणारा आणि समाजातील जे काही प्रश्न आहेत ते आपल्या चांगल्या अशा लेखणीतनं आणि उत्तम लेखातनं वेळोवेळी पेपरमध्ये मांडणारे आमचे मित्र डॉक्टर हेमंत सोनानीस यांना मी विनंती करतो की आता सध्याचा जो महत्वाचा मेंटल हेल्थ ऍक्ट आहे, जो बऱ्याचदा आपल्या सायकॅट्रिस्ट लोकांना सुद्धा माहिती नसतो, याचे काय फायदे आहेत आणि काय तोटे आहेत, याच्या संदर्भात सविस्तर माहिती द्यावी अशी मी डॉक्टर हेमंत सोनानीसला विनंती करतो. डॉक्टर हेमंत सोनानीस सर.
Thank you, Dr. Santosh Kulkarni sir and Dr. Vijay. Can you hear me?
Yes, sir.
Okay. I will share my screen and I will start with my talk. So, as Dr. Archana Pate has mentioned, mental health is very important part of the total health. So I'm very glad that there is a special mention of Mental Health Act 2017 in this conference. Thank you very much. When we speak about the acts for mental health, it started in somewhere in 1851, 1858. In those times, these acts were limited to mainly for British citizens and their needs who were staying in India. The main act came into force in 1912, which helped us in some things, like it removed the authority of IG prison over all these mental hospitals. Psychiatrists were appointed at mental health hospitals, and the certification by magistrate was made mandatory. Before that, mentally ill people were simply treated as someone who is not fit to live in the society, and hence they would be segregated from the mainstream society. Then came Mental Health Act 1987. But as you could see in this slide, it took a lot of time from our independence, 1947. Indian Psychiatric Society appealed for a
new Mental Health Act in 1949, and you can see 38 years were required for the new Mental Health Act to be passed. That was the kind of ignorance mental health has got in our society. It came in effect only in April 19. However, it was a good act, it was a progressive act. It spoke about the admission, discharge of the mentally ill people. It provided for protection of their rights. It provided for supervision of psychiatric hospitals, how they work. It established state and central mental health authorities, involved the government, gave the government the responsibility to supervise the mental health work at the government level as well as the private level. Then came the Mental Health Care Act 2017. This decision was taken by our Ministry of Health and Family Welfare in 2010 that we need to amend the Mental Health Act 1987. Why this new act? It is basically because of the UNCRPD. UNCRPD is United Nations Convention for Rights of Persons with Disability. So this UNCRPD was adopted by General Assembly of UN in 2006. India was one of the few countries which signed and got legally binded to this UNCRPD immediately in 2007. Naturally, it became a responsibility of the government of India to be more committed to the human rights with persons with disabilities, which of course included persons with mental illness. Most of us must be knowing that in our total budget, the health is getting only 1% of the total budget. And of this 1%, meager 0.6% is given to mental health. And of this 0.6%, majority goes to the mental hospitals run by the government. So there was hardly any amount spent on the mental health in public domain of the society. And there was an urgent need to correct this balance. UNCRPD only made the government aware of what was needed to be done as early as possible, and by signing that, India committed to give mental health and the people with mental illnesses their rights in various ways. So the drafts were released 2010, 12, 1 draft, 2 draft, and soon the committee realized that there were too many amendments, and it was decided by the government that we will form a totally new act for mental health. This bill was passed in 2017. So let us have a brief look at what's this MHCA. We call it as MHCA 2017, Mental Health Care Act 2017. I will brief salient features which will be useful for general knowledge of all the medicos, all the doctors who are not psychiatrists. We psychiatrists are studying it in detail, and we are in touch with the government, Director of Health Services, Health Secretary, State Mental Health Authority for implementation and for various suggestions and corrections. We will focus on some important points which you all should know. So MHCA basically is focused on the healthcare related aspects. It doesn't go into legal part, it doesn't go into civic, political rights, voting, guardianship, etc. It is basically focused on the treatment part and the rights of persons with mental illness regarding their treatment, capacity to take decisions about their treatment. So what are those rights? Let us look at a few important things in this fact. One thing is advance directive. Means any person with or without mental illness gets right to make an advanced directive. Advance directive means he or she states that how he would wish to be treated for a future mental illness and how he would not. I will like this kind of treatment. I will not like this kind of treatment. This is given in written, signed in front of the witnesses by a medical practitioner, and it is a legal term. So this gives the person with mental illness to decide about his or her own treatment. Of course, it could have led to many difficulties in practical treatment. So our act includes provision to challenge this AD by families, professionals, mental health professionals, psychiatrists. If the treating psychiatrist thinks that the nature of the mental illness requires this kind of treatment and it is not included, then there is provision by the mental health professional to appeal to Mental Health Review Board, which is appointed at district level by the state mental health hospital. So this is the chain. Patient is nominated representative, and coming to that point, the treating mental health professional, the local mental health review board, at state level there is state mental health authority, at central level there is central mental health authority. So this way we are focusing on not only ensuring that the persons with mental illness get their rights, deserving rights to decide about their treatment, but also there is supervision by the treating mental health professionals, as well as the caretakers, as well as the government. So this is the second part. The person with mental illness has the right to appoint a representative, to nominate a representative. It is called as NR. So this NR is a legally nominated person to act and to decide on behalf of the patient when his or her mental illness is to such severe extent that they cannot decide about their own. This is the important part of treatment of mental illness. Difference between physical illness and mental. Any physical illness, that person would be in mentally right condition to decide about his treatment, to know, to understand about his illness. But when the mental illnesses become severe, like schizophrenia, like mania, many times because of lack of insight, because of lack of touch with reality, patient sometimes cannot understand the nature of the illness, the need of the treatment. At such time, he has already nominated a representative, a legal representative, who will act and decide on his behalf. Who can be the nominated representative? It can be any person if it is appointed by a person legally with a document. If it is not nominated, then there is deemed NR. Deemed NR is first of all family member, relative, then a caregiver. If there is nobody, then the Mental Health Review Board and the government will be deciding on that. So some very basic things, you might think these are such basic things, but mental illness and mental health require special mention of these things. So person with mental illness has right to access to mental health care, treatment and services at hospitals, mental health establishment run or funded by the government. Free treatment, BPL persons, destitutes, homeless people. Equal quality of treatment like as compared to any other physical. So the treatment of, like it used to happen in our UG curricula, even when I was in MBBS, psychiatry was an optional subject. Medicine 3 months, surgery 2 months, gynec 1 month, psychiatry 15 days, optional, you can do psychiatry or you can do ENT, something like that. So somehow we have grown up in that kind of educational system where psychiatry was generally treated as a side branch. But each person with mental illness is a very special one, and his own problems are very, very unique and most important for his or for her life. So these rights are very important. So no discrimination, whether it is mental illness or physical illness. Medicines free of cost at all governmental hospitals. Protection from cruel, inhuman, degrading treatment. No punishments. Safe and hygienic living environment. Sanitation, recreation, clothing, food, sanitation. Right to refuse water. You might have seen many centers like rehabilitation centers or hospitals in the past, or we generally think that it is a good practice. Of course, it is a good practice. We will call it as vocational rehabilitation, occupational rehabilitation. But that person should have right to refuse the water. There should not be force. Person should receive the appropriate remuneration for it. Protection from physical abuse, emotional abuse, sexual abuse, very important. And right to move a less restrictive community-based establishment. So the focus is on not institutionalization, but rather in the opposite direction, community-based care. A person with hypertension, person with diabetes, person with cancer, all of them get their deserving freedom to take treatment from their home, from the community. It was not there 100 years back. It was not there 50 years back, but slowly and gradually, it is a welcome step that a person with mental illness is getting the right to decide on which kind of establishment, which kind of setup he or she can take. No forced tonsuring, no compulsion to wear uniforms, and no discrimination on it. Right to access medical records, right to complain against deficiencies in services. There are minimum standards for mental health facilities, and most importantly, there is decriminalization of suicide. What are these minimal standards? We have just gone through most of this, all very basic but very important. Right from food, water, sanitation, space, then no torture, no punishment, no isolation. Very important, the second half of this slide, no chaining. There are some situations, most of them are not run by the psychiatrists or doctors, but there are many such setups in our society. We all know that patients are chained because of some myths and misconceptions or some superstitions. So no chaining, no roping, chemical and physical restraints to the minimum only in the case of to prevent harm, that too by proper permission of the head of that institute. Privacy, dignity, safety and security, especially of women. So all these are the rights and the minimum standards which are focusing on the basically the right to take the decision about the treatment and the right to get the good quality treatment in a good quality setup with all basic needs satisfied. So what are the responsibilities of the state? To provide all adequate acute mental healthcare services, outpatients, inpatients, overall across the country, in all the states, in all the districts. Services such as halfway homes, sheltered accommodation, supported accommodation. When acute treatment is done, then if there is some period where person cannot go back to home, then halfway homes, sheltered accommodation, or where the person will not be needing an indoor treatment, but because of the poor support system, the government is expected to provide this sheltered accommodation, supported accommodation when there is no caregiver. So domiciliary care and attendant can be provided. All these will be responsibilities of the government to establish all this setup. The Mental Health Care Act is still very new and all these things are still going on. Reimbursement of the cost of treatment in a non-government health establishment where where there is no mental health services available in that district. And most importantly, to spend more time, to spend more money, to use more resources to increase the awareness, to remove the stigma, to sensitize the society about the mental. Most of the psychiatrists, associations, private setups, we are doing these awareness activities at our level, like it was mentioned in my introduction, writing articles or giving talks, but it will be a major responsibility of the government to work on this issue. There is central mental health authority at central level. There is state mental health authority at state level. They will register and supervise all mental health care establishments, maintain a register of these establishments, maintain a register of mental health professionals at central and state level respectively. Then the state mental health authority will constitute a mental health review board, which will be functioning in one particular district or a group of districts depending on the need availability of the experts. The things we discussed, important points like advanced directive, nominated representative, it will be the responsibility of mental health review to educate complaints against mental health establishments, conduct the inspection and audit of mental health. Psychosurgery, recently there was a news I came across on Google that psychosurgery was performed at hospital recently. Very clear and very defined criteria, informed consent of the patient, approval by the treating psychiatrist from the mental health review board. The mental health review board can speak to patient, can speak to mental health professional, and then only this psychosurgery can be done, because it is supposed to be used in very rare cases, and the persons with mental illnesses should not be used for experiments. No ECT without anesthesia. In the past, there were direct ECTs without anesthesia. Now there is no such ECT. Restriction on ECT for minors. No sterilization as a part of the treatment. No chaining. No solitary confinement. No closed wards. No restriction of the persons with mental illness in isolated room. If you remember from the movie Yarana, Amitabh Bachchan was locked in one room. He used to shout. No such inhuman treatment. Even the restriction on physical restraint. A less than 3-year-old child should not be separated from inpatient mother unless there is some typing error, unless there is a harm to the life of the child by the mother because of her mental illness. The measures to reduce stigma we have discussed. The good thing is that there is only registration required, which is a simple process as compared to previous process which required a license. Though they were trying to reduce the paperwork, the documentation, and the time taken. Responsibility of police to take under protection any person found wandering who appears to have mental illness and is incapable of taking care of himself or is a risk to himself or to others by reason of mental illness. Decriminalization of attempt to commit suicide. Most of us know that suicide attempt, then MLC, the police will come, the police will talk to relatives, police will talk to patient. The person is already having mental health issues, and because of that stress or depression or schizophrenia, person has attempted to harm himself or herself, and then police interrogating everything. So decriminalization, which was there mentioned in the previous acts. Second important point is insurance of mental illness. This is another important point which was very neglected until yesterday. So all the insurance companies are expected to provide insurance for mental illnesses in the same way as they provide for physical illness. So these are the important points I hope I have covered. all the important points which we all should know in our day-to-day practice whenever we come across a person with mental illness visiting your hospital, your establishment, or whenever you are discussing any person with mental illness with your psychiatrist friend. I hope if you know all these points, you can help your patient in a better way. Thank you.
Thank you, Dr. Hemant. Thank you, Dr. Hemant, for such a lucid presentation of an important topic. I must confess, I also didn't know a single word about this act before this lecture. So thank you for enlightening us. There are few questions which are there in the chat box. I think
Yes, Dr.
this has
Kush,
been
please
asked-
take. Yeah.
This has been asked by Dr. Sheetal. They say the person handling them needs psychiatric treatment and not them. How can you not force treatment?
Can you repeat? I could not hear completely.
Yeah, they say the person handling them needs psychiatric treatment and not them. How can you not force treatment? Or how can a mentally ill patient decide whom to nominate and how can their nomination be taken as logical?
Okay. Ideally, every person has the right to or capacity to decide about his or her own treatment. That is one part. Second thing, yes, if the nature of the suspected mental illness is such that the person is often not willing for treatment or refuses to come to the doctor or refuses to get admitted. So in such a case, there is nominated representative. So the nominated representative is a legal person who has the right to act on behalf of the treatment. In such a case, the nominated representative can decide whether the patient requires outdoor treatment or indoor treatment or admission. Admission can be independent admission by the request of the patient himself, or in other cases, there is supported admission where the nominated representative or family member request a mental health professional for admission because the nature of mental illness is such that the person with mental illness might cause harm to himself or herself. But here we need to understand that our traditional concepts of forcing persons with mental illnesses for treatment are not going to work in the same way as they worked in the past. Because the focus is on the right of the person with mental illness. So the supported admission will only act in case of emergency situation when there is risk to the patient himself or risk of harm to others or risk of harm to damage of property. In such cases only this can be done. The practical question, what to do if patient is not listening to me and refusing to come to the doctor. In such cases, practically the relative can or family member or the nominated representative can go and consult a nearby mental health professional in private setup, in government setup, and accordingly, after assessment of the situation, if the mental health professional thinks that irrespective of what patient is saying, if it is necessary to treat him in this situation, then they can take help of the legal authorities and get the patient admitted for treatment.
Yeah, agree, Dr. Hemant, sir. Just the last one.
Nominated representative, there was a question, who can be the nominated representative?
Yeah.
The person with mental illness can nominate any person as his NR if he does, but it is not compulsory for that person to nominate at NR. So it is his right, but it is not compulsory for him. In case he does not nominate anybody, then there is deemed NR. Deemed NR is family member or relative will be the first choice. If there is no family member, then any caregiver who is accompanying or who is staying with the patient will be the NR. If there is nobody, that person is all alone, then the MHRB, Mental Health Review Board, will take responsibility to take decisions on behalf of that person.
Okay, thank you. So now this is the last one. What will be the take-home messages from your side for a non-psychiatric doctors like us? I am a pediatrician, and about mental health law, because this was totally a new topic for all of us.
Right. As you rightly said, most of us are aware of that, are unaware that there is any such act for mental health, especially. And I really thank IMA Dombivli for including this topic, because mental health, being a psychiatrist, is very close to my heart, and it is also very important for the society as well. So the take-home message for all my non-psychiatrist colleagues will be that we need to get over some of our traditional concepts. No isolation, no chaining, no locking, no more closed wards. There will be open wards. There will be no locks to psychiatric wards. There will be no locks to psychiatric hospitals. There will be no compulsory isolation in particular room. And there will be no compulsion for uniform. There will be no compulsion for the treatment unless it is an emergency. There is no necessity for doing MLC for suicide attempt. But it is necessary that if you are admitting mentally ill persons in your hospital, then it should be registered with State Mental Health Authority as a mental health establishment. There is a form which is supposed to be duly filled. It is a simple procedure. The good thing is that only registration is necessary, no licensing. So you can just submit the registration, and even your Bombay Nursing Home Act registration can be attached to it, and it is sufficient. Of course, that does not mean that one can get away with any kind of atmosphere once the registration is received. There will be periodic supervision, inspection, and audits by the mental health review boards. And one more important thing, last but very important, financial part, insurance. Mental illnesses can be covered in your hospital through insurance companies, all kinds of insurance companies, just like any other physical thing.
Thank you, Dr. Hemant, for making it so simple and basic. Thank you. So thanks to my co-chair, Dr. Santosh sir, and thanks to Dr. Archana Pate madam for making us participate in this important summit. So over to organizers. Thank you.
Yes. Thank you, sir. It was a really very insightful lecture. I think not only doctors, but in true sense, law personnel or advocate and police personnel should also be trained about this act, because I can see there are so many so-called de-addiction rehabilitation center which are nowadays only a dumping ground. There are many patients are dumped. They are not taken the license of psychiatric nursing home, neither fire, nothing, because the laws are only for the doctors, not for so-called those, they are not having the degree. So all these persons should be made aware of this law, and hope after proper enactment of this act, it will truly work for the safeguard interest of mentally ill patients. So I request today chairperson Dr. Santosh Kulkarni sir to summarize the session.
डॉक्टर हेमंत सरांना ऍक्च्युअली समराईज करायच्या आधी एक माझा प्रश्न आहे की ह्या मेंटल हेल्थ ऍक्ट मध्ये माझ्या माहितीनुसार आयुर्वेदिक आणि युनानी डॉक्टरांना आयुर्वेदिक उपचार करण्याची म्हणजे प्रॅक्टिशनर्स म्हणून म्हणजे मानसोपचारची प्रॅक्टिस करण्याची काही अट घातलेली आहे का? आणि आता प्रत्येक जिल्ह्यामध्ये बरेचसे आयुर्वेदिक डॉक्टर्स व्यसनमुक्ती आणि मानसोपचार केंद्र चालू करतायत. कारण मी अँटीक्वॅक्रीला स्टेटला चेअरमन असताना असे बरेच प्रॉब्लेम यायचे. तर ह्या ऍक्ट मध्ये त्यांना प्रॅक्टिस करायची परमिशन दिलेली आहे का?
मेंटल हेल्थ प्रोफेशनल अशी एक कन्सेप्ट आहे. तर मेंटल हेल्थ प्रोफेशनल हे फक्त मेंटल हेल्थ एस्टॅब्लिशमेंट रन करू शकतात, त्यांच्या नावावर रजिस्ट्रेशन होऊ शकतं. आणि तो सायकॅट्रिस्ट पाहिजे आपला मॉडर्न मेडिसिनचा असं तिथे नाही म्हटलेलं आहे, कारण त्या होमिओपॅथीमध्ये पण सायकॅट्रीची डिग्री आहे, पोस्ट ग्रॅज्युएट डिग्री आहे. तर जो पर्सन त्या क्रायटेरियामध्ये फिट होत असेल, दॅट कॅन बी ही और शी कॅन फंक्शन ॲज अ मेंटल हेल्थ प्रोफेशनल. मग त्यामध्ये क्लिनिकल सायकोलॉजिस्ट, त्यानंतर सायकॅट्रिक नर्स, सायकॅट्रिक सोशल वर्कर हे सगळे येतात. परंतु तरी सुद्धा सायकॅट्रिस्टचा रोल खूप महत्वाचा आहे, कारण जे आपण ज्याला सपोर्टेड ऍडमिशन म्हणतो किंवा सर्टिफिकेशन म्हणतो, या सगळ्या गोष्टींसाठी सायकॅट्रिस्टच लागतो. आणि सुदैवाने त्या ठिकाणी इंडियन सायकॅट्रिक सोसायटी आहे, इट इज व्हेरी proactively communicating with the state health department and working out on all these issues, because as I said, 2017 this act was passed, it was implemented, it is still getting implemented in Maharashtra, and so it is going to be a process, and so many things will get clear in next 1 or 2 years. हो, पण आयुषला त्यांनी मेन्शन केलेलं आहे, त्यांचे जे मेंटल हेल्थ असतील क्वालिफिकेशन, तर ते तिथे कन्सिडर केले.
So thank you so much, Dr. Sonanis. I think it was really wonderful because as Dr. Kush rightly said, for non-psychiatrists like even me, because I am a physician and intensivist and I really never knew so much about a Mental Health Act. And mental health is, I think, one of the things of prime importance. We are talking about the act which is talking about patients who are mentally ill, but other than that also mental health, I think, is something which has to take equal, if not lesser, importance as compared to the physical health, because we see so many things which are coming up as physical symptoms. Many of them I have seen in my practice is that many of them are originating from issues related to the mental health. And but today's session on Mental Health Act in itself was an eye-opener, and thank you so much for taking the wonderful session. And I now request Dr. Vijay to please present the certificate of appreciation.
Yes, sir. Thank you, sir. Thank you very much for giving such an insightful lecture. On behalf of Indian Medical Association, Dombivli, I am proudly presenting this certificate of appreciation to Dr. Hemant Sonnis, sir, for comprehensive and elaborate session for medical professional on Mental Health Act during online medico-legal Let's Act Summit, organized by Indian Medical Association, Dombivli, on Saturday, 29 July 2023. Thank you, sir. Once again, I am very thankful to our speaker, Dr. Hemant Sonnis, sir, Chairperson, Dr. Santosh Kulkarni, sir, Co-Chair, Dr. Kush Junjunwala, sir. Thank you, sir. With this, I declare the session is over. I request MOC, Dr. Archana Pate, madam, to take over for further proceedings. Thank you.
So thank you, Dr. Sonanis, once again. Thank you, Chair Dr. Kulkarni, Co-Chair Dr. Kush Junjunwala, and Moderator Dr. Chinchole for conducting the session so nicely. And with this, we come to the end of sessions in the summit for day 1. And on behalf of IMA Dombivli, I take this opportunity to thank all the speakers, session chairs, co-chairs, moderators of all sessions. We begin tomorrow sharp at 9:30 a.m. I'm very happy to say that we have 1100 registrations for today's conference, and people over the entire 6 hours today. Almost 1,000 people have entered and left the summit. I mean, attended, I think, the sessions of their liking or what they wanted to attend, but almost 1,000 participants have entered and left at some point in time. And I'm happy to see that till the end of the session, we still have 200 delegates in the summit. I'm sure that the numbers will be much, much more tomorrow. So we continue this journey tomorrow. We begin in the morning at 9:30 a.m. sharp. Please use the same Zoom link to join the summit tomorrow. Please note that to avail MMC points, attending session on both days is important. And once you join, please do put your name and registration number in the chat box. Have a very good evening, all of you, and have a great weekend. See you all tomorrow. Thank you so much for joining.